That's that. Morning, folks. This is before the Arkansas Pollution Control and Ecology Commission in the matter of Vista LLC Class 4 landfill. It's a consolidated docket number 23-008-P. For the record, my name is Charlie Moulton. I'm the administrative law judge for the commission. Counsel, would you be so kind as to identify yourself for the record, please?
Lisa Thompson, Department of Energy and Environment.
Ross Nolan on behalf of Mayor E.G. Russell and the city of Tommytown.
And everybody's standing, and it's fine if you want to. I'm not. You don't have to. Go ahead, Mr. Mays.
Thank you, Your Honor.
That's fine. I understand.
See with the council team, Volker,
Folks, thank you so much. For those of you that have not appeared before me in terms of a motion hearing, what I like to do is I like to take up each individual issue that's been briefed separately, as opposed to just having you get up and argue the entire thing. It makes a better record in my mind, and it makes it more understandable for me when I go back and look at a transcript if it's just parsed out like that. So the first issue I would like to take up is Mr. Mays's certificate of need, and I understand what's been filed. I understand Ecovista has filed a response saying it's untimely in terms of his motion for reconsideration. But looking at Rule 60, it says you have, I think it's 90 days to set aside an order. So, Mr. Mays, why don't you go ahead and take the podium, if you would, and we'll take up the CON issue first. And it's not on your motion for summary judgment, really. It's going to be on your motion for reconsideration. Go ahead, sir.
I appreciate that, Your Honor. I want to make clear in raising this issue again, and I'm mindful of the ruling you made on the motion to dismiss that the Ecovista and the agency filed. I'm not being disrespectful of your ruling, but I firmly believe that this is a legitimate issue that I have not been able to so far make clear the position, and I assume responsibility for that. But I do think it's a very important issue. We are not challenging the certificate of need in a collateral way. We acknowledge that the district, the waste management district, issued the certificate of need. It was not challenged at the time that it was issued. There's no question about the validity of that particular certificate of need. But there were also with the going along with certificate of need, is the limitation on the effective date, effective time in which that certificate has an effective life, so to speak. The regulations of the district state specifically that where the certificate of need accompanies an application for a permit, that it has to be filed with the application at the department within 6 months of the date of the issuance of the certificate of need. There is no provision for exception to that. There is no procedure that I saw in the regulations. The regulations are part of the application that was filed by Echo Vista, and it's part of the record. And the regulations make clear that 6 months is the effective time that the certificate of need is in effect after it is issued, and has to be filed with the department within that 6 month period on an application for a permit.
Well, let me stop you right there, Mr. Mays. So the first question I've got for you is, what's the remedy you're seeking for this?
The remedy?
Yes.
The remedy would be to require require Echo Vista to go back to the district and to obtain a certificate of need that they file with an application for the permit within the 6 month period that the certificate of need is in effect.
Part of your argument, though, is that the district didn't follow its own rules, correct?
Well, partly, yeah. Well, no, actually, we don't.
Hold on a second.
Okay.
From what I've read, you said they didn't have the authority to issue these extensions under their rules, right?
Yes.
So essentially, what you're arguing is that the district acted ultra vires, correct?
The district could not extend it. Yes.
Okay. So you understand the exhaustion argument that's already been part of the motion to dismiss and my rationale for that. In order to get to what you want, don't I have to issue a finding that the district acted ultra vires?
Yes.
Okay. How do I do that if they're not a party to this case?
Well, the tribunal that issues the order does not have to be a party to the lawsuit for the court, this court here, you determine that on the face of it, and given the 6 month limitation in the district's regulations, that on the face of it, that certificate of need was no longer effective when it was filed 2.5 years later.
But Mr. Mays, I still have to issue an order finding a party who is not, finding an entity who is not a party to the proceeding, that they violated somehow their own rules, which again is why they have the exhaustion in terms of the exhaustion argument and in terms of the appeal process. When you are challenging anything that the district has done, there's that appeal process that's set out in 22, and it gives the district an opportunity to respond, make it part of the record, give them an opportunity to defend themselves in terms of what they did or what they did not do. They're asking me to issue an order in their absence against them, right?
We are asking the court to determine that order that was issued by the district it's not that it's invalid. What we're saying is that it was not filed within the 6 month period that it was required to be filed with the department by Echo Vista. Where Echo Vista is the one we are claiming violated the regulations.
At the end of the day, well, no, you also said the district violated their own regulations because they didn't have the authority to issue these extensions.
Well,
in order for me to get to there, I have to look at their rules, analyze them, and as I understand it, make a finding that the district violated its own rules. And I have to do that without them being a party.
Forget about the extensions. Forget about.
I don't know how I do that, Mr. Mays. You pled it.
Well, no, I mean, in terms of the issue of whether they were entitled to allow Echo Vista to submit alternative technology to ADEQ. We claimed that that was also illegal because they didn't issue a notice. Forget about that part. The sole issue here, as far as I'm concerned, is whether Echo Vista filed the certificate of need, which we don't question the validity of that. It was a valid certificate of need as far as I'm concerned, but they were supposed to, under the regulations of the district, to file that with an application for a permit within 6 months. They didn't do that. It's not the district's fault that they didn't do that. The district doesn't have an axe to grind in that issue. It is Echo Vista that has the axe to grind.
But the district was fully cognizant of the fact that they didn't file it within 6 months, which is why they gave them a couple of extensions, right?
We claimed that that was ultra virus, yes.
And frankly, if the district thought that their rules were being violated by Echo Vista, wouldn't have been incumbent upon the district to point that out at some point in time during this process?
One would have thought so. That doesn't mean that we have to have the district here before us to have their order invalidated. If the court finds that the district did not have the authority under its own regulations to grant those extensions or under the statutory law, then the court, I think, has the authority in this case to say that certificate was not filed in this case within the requisite period of time, and therefore they have to go back to zero.
And you may very well be right, Mr. Mays, if the district were here, because you're asking me to issue an order that's essentially binding actions that they took. Let me ask you one other question in terms of comment. I know you're well aware that we have this requirement in order for an issue to be taken up by the commission. It has to be raised in public comment. As I understand, this was not. Am I missing something?
No, you're absolutely right. It was not raised during the comments. Our position is that DEQ has an obligation to review these applications to make sure that all of the conditions that are prerequisite to the issuance of the permit and that have to be in the application for the permit are there and that they have been legitimately and legally raised and presented. On the face of it, this certificate was 2.5 years old at the time that it was filed. Granted, there were a couple of extensions that the district purported to issue, but if you read the regulations, which are in the application itself, there is no authority for having granted an extension of time. That's basically, we claim that it should be on the face of it, on the face of the application. This was not a valid certificate of need.
And I understand that. I'm still struggling the fact that you're asking me to issue an order that essentially binds an entity that's not a party, which is why we have the administrative process set up in Rule 22, as I understand. Let me ask you this though. Do you think there are any facts in dispute about this issue? Seems to be that everybody's on the same page. It's just what it all means, right?
Not on this issue. I do not think there's facts.
I mean, this one can be decided one way or the other.
I think it's ready for summary judgment. They have briefed it, even though they claimed it was moved. They briefed it, and I think it's ready for a decision.
And thank you, Mr. Mace.
Thank you, Your Honor.
All right. Nolan, you want to speak to this, or do you want to?
No, Your Honor.
Again, you don't have to get up. You can stick it. It's up to you. Yeah. All right. Pastor. I apologize. I'm not certain who's speaking. I just assumed. Go ahead.
I will be speaking today.
Go ahead, sir.
Thank you, Judge Moulton. Just a few observations to follow up on that exchange. EcoVista's motion or opposition also relied heavily on the hearing orders in place in this proceeding. after the preliminary conference, the court set discovery deadlines, set motion deadlines. It ruled on this issue on the motion to dismiss fairly early on in that process. There was plenty of time between the court's ruling on the motion to dismiss and the motion's deadline for someone to seek reconsideration. That motion wasn't filed. It was filed for pretty much the 11th hour, shortly before this hearing. And frankly, that's just, it's prejudicial. We've been forced to, as Mr. Mays said, are we briefing this? Are we not? That's a situation that was created by virtue of the late filed motion. That's no fault of EcoVista's, and they've demonstrated no reason why they were unable to raise those claims earlier. As a matter of judicial or administrative economy, the remedy they seek here of unwinding this entire process to ask the Waste Management District to do again what it did several times does not make any sense. There's no evidence in the record that the district would reach any decision other than the one that it already did time and time again. So this seems to be more just an effort to kind of just derail the permit rather than any sort of legitimate concern about the action the district would take and where we end up in the final results. I think there is an economy element to all this as well. I think the observations that the argument ultimately relies on the determination that the district's action was ultra vires and inconsistent with its own regulations is paradigmatic. A collateral attack on a party it's not here. And that's simply not proper, let alone the fact it's never commented on. So I think there's just too many hurdles to get over there, Your Honor, to warrant reconsideration.
Let me ask you as well, Mr. Heister, do you think there are any facts in dispute on this issue, one way or the other?
I guess
I
I
understand
sure
it's not really a motion for summary judgment. That's what I've said because it's already been dismissed. This is a motion for reconsideration. But just out of curiosity, do you believe there are any facts in dispute regarding this issue?
No, Your Honor. I don't think there has been any evidence put forward by kind of the de facto plaintiffs here to establish that they would actually be able to show up at a hearing and satisfy all the elements of a claim such that it was dismissed. And if they can't do that on summary judgment, then we don't need a hearing.
Is it your client's responsibility to make certain that they're following the district's rules?
No, and the district is the authority over its own rules. So clearly, and we're entitled to rely on their representation as to what is an adequate lawful action on the district's part. So when the district says, yes, we can renew this, and we are renewing it, and it's done so in a fairly transparent manner, that information is submitted as part of the pre-application. If EQ had any concerns about it, they could have acted upon it. So I think the EcoVista was entirely reasonable in relying upon the actions of the government agencies it was working with.
Assuming that Mr. Mays is right about everything, and assuming that exhaustion doesn't apply, I'll ask you the same thing. I think. What's the remedy? What am I supposed to do? What should I do, in your opinion, if Mr. Mays is correct?
I think all the commission can do under these facts is instruct the district and the agency to try to do better next time. There's been no, the EcoVista has been issued a valid permit. It's subject to challenge, but the commission by unanimous vote looked this day on the application of that permit. We're operating under it today, and we've obtained kind of substantial interest in that permit and cannot be deprived of them simply because some other party, in this case, third party, the district failed to adhere to some requirement in its own regulations. Again, they'd have to demonstrate that somehow prejudiced them. Kind of what because what's the remedy? We go back and the district issues it again, and here we are back all over.
Well, I guess the question I would have would be, and I apologize, I probably need to pull this closer. I remand it back to DEQ, but there's nothing they can do about a CON, correct?
Well, that's correct.
Yeah, I mean, eventually it has to go back to the district with instructions that they did or did not do something at the end of the day, right? Assuming Mr. Mays is correct, ultimately what they would have to do, I guess, would be to reissue the CON, but that would be the district's bailiwick. It wouldn't be DEQ's.
And what I was struggling with in your hypothetical, Your Honor, was you said kind of instructions too.
Right.
But you can't really give instructions to someone party to the proceeding. So it's almost an advisory opinion that, you know, as you read the regulations, something different is required, and an invitation to DEQ or to the district to come in. I mean, again, they're not even here to tell us why we're wrong. So I mean, there's a process, there's a problem there. You're depriving Vista of a permit under which it's kind of established certain rights on the basis of kind of an interpretation of another agency's or entity's regulations. It wasn't even there to defend itself. So I mean, the kind of the due process problems there compound on each other in a way that I think is extremely complex and seems to invite simply more litigation, which again, at the end of the day, if the ultimate result is the district just reissues another certificate of need, what was the point of going through all that? And that's, you know, and I think that's a key area in where the individual petitioners' papers fail. They complain about these violations that may or may not exist, but at the end of the day, they don't identify how did that harm them any.
Thank you, Mr. Master.
Thank you.
Does DEQ want to weigh in on this, or do you want to sit on the sidelines on this one? All right, we'll move on to the next issue. Unless Mr. Mays, there's something else you would like to add to that. I don't mean to cut you off, but go ahead, sir.
No better than to give a lawyer another opportunity to say something. Your Honor, the Echo Vista's attorney has said that we didn't present any evidence of any of this. Well, it's all in the record. It's all in their application. On page 2.2 of their application, Echo Vista says a notice of intent to apply for a CON was submitted to the Boston Mountain Solid Waste District on January 22, 2018. The CON petition was submitted to the district on March 16, 2018, and a public hearing was held on April 18, 2018. The CON was approved by the district on May 10, 2018. The rules and regulations of the district require the submittal of a permit application for a solid waste landfill permit to DEQ within 6 months of receipt of a CON. I mean, it's there in the record and the application. I assume that DEQ read it. And
Well, they also read the extensions as well.
they mentioned the extension.
Yeah.
But the rules are there also in the record. You read the rules, there's no authorization at all for any kind of extension of the CON. So, if the law says it must be, or it shall, the words are shall be, if it's not submitted within 6 months, it shall be void. Words to that effect, shall was used.
But it's the district's responsibility. As I understand it, again, I don't know for a fact because the district's not here. But looking at the rules, my assumption of why it's 6 months is to make certain that somebody doesn't apply for a CON, sits on it for an extended period of time, has it be incredibly stale, and then maybe 2-3 years down the road, there really wasn't a need. So the district has that 6 months in there to benefit themselves, not Echo Vista, not DEQ, It's there to make certain that a timely submission takes place. But in this instance, the district, it seems to me, was kept apprised of throughout the entire process. Now, I understand your argument that they didn't have authority to issue extensions. But again, I'm back to if that's the fulcrum, if that's the tipping point, I have to issue an order saying that they acted ultra virus and they're not here.
That's counsel for the Echo Vista's argument is that what harm has been done. So it went beyond 6 months. The harm is that it's in the rules and the regulations. If we can't follow the rules and regulations as they're written, then we might as well get rid of it.
I understand that, but again, there's an administrative process in place. And if we don't follow the administrative process that's in place, we might as well get rid of that too.
But you mean for appealing?
For appealing it, yeah.
But we didn't have a problem with the con.
Well, I understand you don't have a problem with the underlying, but again, this was going on for a time frame when it was submitted with the application.
There was no notice.
It was possible for you to challenge it at that point. You were aware that it was the extensions had taken place. And I'm guessing if somebody had looked at it, they would have been aware that the district did or did not follow its own rules.
I think it's not an undisputed fact that we were not aware of it. There was no notice given. They didn't follow any notice or opportunity to comment. In fact, I think the rules of the district also require that whenever there's a rule to be adopted, or regulation to be adopted, or amended or modified, you have to give public notice of that. That was not done.
I understand. I
don't mean to be like this, but it's an important issue. Thank you, Your Honor. I appreciate the argument.
Yep, no problem. All right. Next issue is data service of the permitting decision under Rule 8.211 B1 and C. Mr. Nolan, this is yours. I have to admit, I'm wondering why it's there. So, if you could.
Your Honor, 8.211 contains a shall requirement. And we have clear case law in Arkansas that shall means shall. Here, the department did not issue the permit via mail the same day that it was signed. I mean, this is a clear legal issue. You've been asking Mr. Mays if there's any facts at issue with the development or the revelation from the mail service provider that the permit was not mailed until the 20th. There is no fact here. The fact at issue here, the only matter here is that they violated 8.211 when they did not issue the permit the same day that it was signed. Now, again, this does have implications because people get late notice. This is a public agency that's part of its mission is to involve the public and provide notice, and they failed to do so here as required by their regulation. It's a clear violation of 8.211, and I don't see any way out of it for the agency.
What's the remedy?
The remedy is to remand the permit to the agency and have them properly issue public notice.
What's the purpose behind the public notice? It really is service, isn't it?
Yes.
Okay. So does service have anything whatsoever to do with the merits of the permit?
No.
Why do we need to know when service occurred?
There is a requirement in the rules that they provide service in a manner that would allow people to engage in an appeal before this commission.
You need to know when service happened. So you need to know when the clock starts in terms of filing your appeal for within the 30 days, correct?
Yes. So they've taken days from the public and kept those despite a clear requirement to issue service the same day that the permit is signed.
But Mr. Nolan, you won that. I mean, I've already ruled in your favor on that. Why would I need to remand if all it is a time computation?
Again, this is an issue of service to the public. We've raised it as a violation of their very own rules that they have failed to follow here.
not representing the public, you're representing the city and the mayor, right?
Yes,
Okay, and and your request for hearing was deemed timely filed.
yes, Your Honor.
Okay. All right. Anything else you want to add?
That does not excuse their inability to comply with their own rules.
Well, again, in terms of, I'm not quibbling with you. I'm just saying, in terms of a remand, you want a do-over. You want to expend a whole bunch of taxpayer money to do this do-over. I understand that there was a technical violation, but at the end of the day, how has it harmed your client?
I don't believe that harm to my client is an element of standing to bring a rule. I mean, we've got that is Ecovista's argument that you must prejudice in order to.
That's what the case law says too.
Well, we also have case law that says shall mean shall.
I understand.
And I've provided older cases where different forms of public notice were given. And they said, just by virtue of not performing the public notice correctly, that is a violation. And they weren't in the administrative context, they were in other contexts. But again, shall mean shall.
All right. Again, I'm going to ask you because you really didn't answer my question. I understand that, you know, through the mistake of their, I guess, what is it, a courier service? I'm not even certain, or mailing service. They thought it was going to be mailed on the 17th and never did get mailed out until the 20th. At the end of the day, though, was your client harmed by this, the city or the mayor?
No, we've received that ruling.
Okay. All right. Anything else you want to add?
No, Your Honor.
All right. Thank you, Mr. Nolan. How about DEQ on this one? Anything you want to add to that?
No, Your Honor.
High Street? All right. Thank you. All right. The next one I have is the failure to properly respond to the Tawny Town resolution. So, Mr. Nolan, I think that one is yours. The mayor submitted, I believe, both resolutions to DEQ as part of public comment. You took exception to the division's response to that comment. Go ahead, sir.
May I clarify for a moment? We have separate counts. One is that the
We
approval.
have the generic public comment, which I think is the I'm not even certain what it is, 607, 22607, which is the, I'll encapsulate as the public nuisance aspects, right? Is that right?
No, that's another one. That's
Okay.
the factual issues regarding fire and litter and that sort of thing.
Let's just keep it because as I read your motion for summary judgment, this one was raised independently and separately from all the other public comment ones.
Okay, and then, I mean, we have the greater issue of whether or not, of the law surrounding withdrawal of approval. Are you prepared for that right now, or?
No, we're just on the response to the comment.
Okay,
Because it's a point that you got in your motion for summary judgment.
yes, and
Okay.
I just want to make sure I know exactly what I'm addressing right now, because I do have other related arguments pertaining to.
Down the road.
Your Honor, the public comment period must be given meaning. You know, as we have pointed out in this proceeding, and this more goes to 22.607, there were hundreds and hundreds of comments given during this proceeding, and there were 0 changes made to the permit. And that is just a baseline problem to us, but specifically in regards to Mayor Russell's comment, submitting the November of 2022 resolution, DEQ's response was singular. It said DEQ acknowledges the subsequent city resolution withdrawing support. This is not a response. This is not an analysis. This was confirmed in Mr. Zweifel's deposition. It confirms ADQ simply ended its review with nothing more. This is not an action in response to 22.203 written denial. It is truly arbitrary that ADEQ honors a now revoked 2018 resolution while ignoring a contemporaneous one submitted during public comment, demonstrating the pre-application approval no longer exists. 8.211 requires a response to each issue raised in any public comments. A response to the November 2022 resolution is not in the present record. There's only an acknowledgement. Again, acknowledgement is not equal to response.
Didn't they acknowledge it in terms of their acknowledgement? Wasn't the acknowledgement also that, and I could be thinking about deposition testimony instead, that they acknowledged the comment and that the city had withdrawn support for the expansion?
I asked Mr. Zweifel that in depositions. I cannot immediately recall somewhere in the response to comments that statement was made by the agency.
Perhaps DEQ can help me out with that when we get to that. Let me ask you this though, Mr. Nolan. So 8 to 11, it talks about shall include a response, but then it goes further and it says, in the case of any discharge limit, emission limit, environmental standard, analytical method, monitoring requirement, it's going to have a written explanation in the rationale for the proposal, which demonstrates any technical requirements or standards based upon generally accepted scientific knowledge and engineering practices. And then it goes further and it says, you don't need to do that if there's a specific regulation that you are relying on for this particular emission limit, discharge limit, method, etc. And then the tail end is, in all other cases, the department must provide its own justification with appropriate reference to the scientific and engineering literature or written studies conducted. So I've read both resolutions. They don't require a scientific or an engineering analysis, correct?
No, Your Honor, it's a legal issue.
Right. And they don't, there's no studies, there's no anything. The resolutions are pretty straightforward and in plain English. I mean, they're pretty easy to understand. Now, I know you're quibbling about the legal significance of those resolutions, but does 8.211 require a legal analysis from the division?
It requires a response.
Okay.
That's the first line,
Right.
regardless of what comes after that.
Well, they did respond. They acknowledged the comment, right? They did respond. But in terms of the remainder of 211, it's oriented towards science, engineering, analytical, as I read it. Again, I understand there's a divergent view of the legal ramifications of the resolutions. But I look at 8 to 11, and it doesn't require a legal analysis.
I wholeheartedly disagree that they have responded. Acknowledging the existence of something is not a response.
Well, maybe they did more than that. Again, I'm going off the top of my head, which as I get older is not used to be. And I've read a lot of stuff. So I may be confusing what you mentioned in terms of the deposition testimony and their actual response to the comment. I just don't recall off the top of my head what that response was.
I asked Mr. Zweifel, did the agency's consideration of the resolution end at review? And he said, yes. Again, that is not a response. That is not a providing any insight into what it is the ADEQ, the agency, is making their decision upon. And they, of course, have to provide a rationale for why they do what.
Well, they have to provide a scientific, again, the rule that you're citing, 8 to 11, they've got to provide a scientific basis, an engineering basis, a regulatory basis for the laundry list of things that are in 8 to 11. but the resolution really doesn't fit into that. What you're asking them to do is provide a legal analysis, and I understand why you would want that. Frankly, I would have loved to have seen the legal analysis as well. But looking at 8.2.11, I don't see that it requires a legal analysis. What the city did was change the tapestry a little bit. And from a legal perspective, again, we're going to quibble on what it means, but it's a legal analysis. It's not a scientific analysis. And if you can point to me specifically language in 8.2.11 that says the division is required to provide a legal analysis to what is essentially a legal comment, I'd be happy to be open to it. I would.
Well, I mean, I think we've already identified our rub here, Judge.
Yeah.
And that's that I think that I am arguing that acknowledging the existing of something is not a response. Like we have to be able to look at the record and the response to comments and understand why the agency arrives at the decision it does. And simply saying DEQ acknowledges the subsequent city resolution withdrawing support is not a response to the issue. That is punting. And we can't have that because we then have to go and be able to appeal the decision made. So
the concern that I've got with your argument, Mr. Nolan, is that there are always, particularly in a high profile case, numerous public comments that are completely out in left field. And yours that have nothing to do whatsoever with the permitting decision, that have nothing to do with the science, have nothing to do with engineering. It could be something along the lines of, my property values are going to go down. If I take what you're saying, it's incumbent upon the division to provide a legal analysis on why or why not those property values are going to go down or not, if somebody does that, as opposed to just saying, we acknowledge your comment, because at the end of the day, what ability does the division have to control property values? You see the concern I've got? I don't want to issue an order that basically binds this division to respond to the most superfluous comments that they get. And they get them. And I know you've seen them before. If we go down that road, that we need something with a lot of traction and a lot of substance, as opposed to just acknowledging that the comment was made, I think we're opening up Pandora's box. That's the concern I've got.
Well, two responses. First, this is not a superfluous comment.
I understand that. I understand that. But again, I'm looking at 8.2.11 and the verbiage is oriented toward science, engineering, not legal.
I mean, with your example, to me, a response could be as simple as property values are not considered by the agency. That is a response. That is one sentence without further analysis, but that responds to the issue. Here, we don't have a response to the issue. It's not in the record.
Let me stop you there because let's see what they actually have in the record. If you could, Ms. Thompson. What was the response? I just don't remember.
Yes, on page 57 of 125, DEQ, this was exhibit number 12 in DEQ's motion for summary judgment. Page 9, DEQ responded to the mayor's lengthy comment regarding years of complaints about landfill operation, odors, city growth, and the November 2022 resolution with the following, quote, Class 4 landfills do not accept putrescible waste and odor is mitigated through weekly cover. In the 50 site visits to Echo Vista in the last 2 years, DEQ has not noted any violations of the Class 4 landfill. DEQ received a con and host community approval with the pre-application and application. DEQ acknowledges the subsequent city resolution withdrawing support. So, Your Honor, it was more than a sentence. Then again, on page 74, DEQ responded to an additional comment from the mayor and stated DEQ is aware of the resolution passed by Tawnytown City Council. That was, again, page 74 out of 125 attached as 13.
I got you up here. Anything else you want to add in terms of your argument?
No, Your Honor, again, DEQ sees 8.211 as not having to provide a legal argument for the resolution.
Thank you. Lester?
Judge Moulton, I think you're spot on to be concerned about the practical consequences of a rule like this. For any agency trying to operate in the real world, the expectation that they can litigate all these legal issues through comments, and of course be at the risk of being deemed to be acting arbitrarily or capriciously if they fail to identify some legal response. Because make no mistake, if they had responded more fulsomely to this in a legal format at the comment stage, the argument you'd be hearing was, well, yeah, they raised those arguments, but they didn't raise these other ones, so they can't raise them now. It puts the agency, and more specifically the permit writers who are not attorneys, in an impossible position. It puts the agency staff in an impossible position. And it's extremely telling that the only rule that requires more detail is, as you've observed, one for scientific or technical data. And all this ignores the role of the commission in all of this to ultimately decide what is and is not lawful. It's not as if DEQ is the final stop in the permitting process. DEQ can have an opinion about whether what they're doing is lawful or not. In some cases, I represent clients who agree, and sometimes I don't. But at the end of the day, it's the commission who decides what is lawful or what isn't. So, it just doesn't make any sense to try to force an agency to kind of at a public participation comment stage respond on the abbreviated, the timelines that they're subject to at a legal level. That is not how the process has worked, and there's no reason to expand it and apply that way here.
Thank you, Mr. Ashton. Mr. Nolan?
Very quick. I'm not trying to mislead the tribunal when I say what I read earlier is the only line. Everything that came before that in response, in my mind, goes to 22.607. I mean, let me be clear on that.
That's fine. But in terms of, they acknowledge the comment, they acknowledge that the city withdrew support. I don't think they need to do more than that under 211, because I understand what you're saying. You were looking for more of a legal analysis. What does it mean that the city's withdrawn its support? But I just don't think 211 requires that. Now, within the grand scheme of the permitting and other provisions of Rule 22, yes. But 211, I just don't think. I think it's apples and oranges, at least from my mind. Go ahead, Mr. Nolan. I'm sorry.
The problem here is what we have. They don't respond in public comment, and then we get a post hoc rationalization in response to the motion. That's the problem that I'm identifying here. We have to know, based on the response to comments, what it is we can appeal. And that's the problem of going this direction, not giving meaning to response and just allowing acknowledgement. And that is a big issue, which is manifesting itself here. But we will go to the legal arguments. That's what we're going to hang our hat on 22.2.
Understood. I apologize, Mr. Mays. Well, you didn't move for summary judgment on this. That's why I've skipped over you. You had your public comment generic and your certificate of need. But go ahead, sir.
Your Honor, I've been married twice. I'm accustomed to being ignored.
As I've told you, I've been married almost 40 years. So.
Congratulations. Wish you the best. I want to make sure what we're talking about. I don't want to weigh in on the issue of whether the agency had an obligation to comment on the orders or the resolutions. I mean, Mr. Nolan, I think, has stated his case, and I'm supportive of that. In our appeal, in our request for a hearing, we also raise the issue of the failure of the agency to respond properly to certain comments. Those comments had to do with the operation of the landfill. And the court has already overruled the motion to dismiss by Echo Vista and the state to dismiss that appeal because we claim that the agency failed to respond to factual comments about the conditions at the landfill, the way it was being operated and so forth. That is not the subject of any motion to dismiss, a motion for summary judgment that I'm aware of.
I think both DEQ and Ecovista raised that in their motions for summary judgment. It is. Yeah.
I think there are issues of fact that would preclude that, but are we talking about those issues in this argument that we're having right now?
No,
Okay.
no, we're just talking about, again, I'm going on Mr. Nolan's motion for summary judgment and what he raised as particular points and what he pled.
I just want to make sure.
Yeah, no, we haven't even gotten to that quite yet. So the next issue that I've got, again, this was raised by Mr. Nolan in his motion for summary judgment, which is failure to provide, and again, granted, you raised this, Mr. Mays, in your request for hearing, but not in your motion for summary judgment, and this is a summary judgment hearing, okay? But Mr. Nolan did raise it in his motion, which is the failure to provide adequate notice of a public hearing in violation of Rule 8.209A1. Maybe you did raise this one in the tail end of your motion. Let me hold on a second. Let me take a look. You did, Mr. Mays, on page 9. So both of you can have added on this one. Nolan, go ahead.
Very brief, Your Honor. This argument is akin to the failure to give proper service, as you termed it earlier. Again, the notice for the public hearing went out at a time period that it arrived after the public hearing was given. Again, this is a shall requirement. Once the agency decides they are going to hold a public hearing, they have to provide adequate notice. Now, again, I'm anticipating your next question. Yes, my client showed up to the public hearing and submitted the resolution that is that issue here and gave a public comment. But again, how many times can we allow the agency to erode the public notice and requirements that are held in its own rules before it is an actionable issue that we can remand the permit on and say, hey, you got to get it right. This is your job to involve the public. And here, multiple times in a single docket, they have failed to honor their responsibilities to give proper public notice. So I again acknowledge my client showed up, but this is a shall requirement. We are here to appeal failures to comply with regulations. We have two very clear failures to comply with public notice requirements in this docket.
And the other two individuals that you mentioned in your motion for summary judgment also showed up and made a public comment too at that public hearing. The reason I said it is I read their comments.
I can ask. Okay.
I read the comments. They were both there.
They're present in the room. So
They're present in the room, correct. But all three of them made a public comment at that public hearing. And I'm not disputing the fact that it was supposed to be mailed out on October 28th. Apparently didn't go out until October 31st. It is a continuing problem, or hopefully it is a problem that now is in the past, because it didn't just happen in this case, it's happened in other cases. And I know it's disturbing to the division. It's disturbing to me too, because it throws everything into slight chaos. But at the end of the day, at least from who you represent, and even who you don't technically represent, but you put in your motion for summary judgment, I didn't see that they were negatively impacted. I'm guessing they got notice in the newspaper. I'm guessing they got email notice as well. So it's kind of like belt and suspenders. There's a bunch of notice that's provided. And I don't disagree with you. There was a technical violation of the rule. There was. No ifs, ands, or buts about it. There was.
there's only one form of notice required by the rules.
Right, I understand that.
That constructive notice has not been argued by the.
I understand that. Well, actually, those two types, they have to publish it in the newspaper and they have to mail it out. The email is a bugaboo of mine because I wish it was in the rule, but I don't want to go down that road. But all right, anything else you want to add, Ms. Phil?
Oh, just again, I refer to the older cases that say that failure to give timely notice is no notice at all, and that then the agency or the county clerk or whatever it was in those cases have to do their job. You know, and that's what we're asking here. It's kind of a circular argument to say, yes, we got notice, and we're saying, hey, you failed to comply with your rules, so we don't know who else might have participated. And I understand I don't represent that who else, but it is a problem and it needs to be addressed. And to me, the only way to do that is to remand the permit and say, get it right every time.
Thank you, Mr. Owen. Mr. Mays? Mr. Heister?
Thank you, Your Honor. I just wanted to quickly make sure it was clear on the record that the hearing under discussion was really a second bite at the apple for the public. Your Honor is correct. There was the traditional written public comment period where notice was provided in the newspaper. No one has raised any issue with that. And I don't know if the record from that period was held over more than the traditional day. DEQ might be aware of that. And the hearing that was held was voluntary. DEQ is not obligated to hold a hearing at all. And it would be a little kind of contrary to the general spirit of the rules to discourage the agency from holding public hearings by punishing it for deciding to do so and getting some mailing cards out 3 days late. If the idea is we want to encourage more public comment, then coming down hard on the agency for kind of going above and beyond and having a public hearing when it was not obligated under the law to do so is I think contrary to the intent behind these rules regarding public notice.
Thank you, Mr. Heister. Before I go to DEQ, Mr. Owen, I've got another question I neglected to ask you. Do you know if this untimely notice was mentioned in public comment?
No, because that would have been the end of the public comment
Yeah,
period.
that's what I'm trying to think in terms of.
So I'm not sure they would have even figured it out by the time it ended. And again, that's the
Yeah,
issue with this.
I agree with that. Although I know that the mayor asked for numerous other public hearings post this public hearing, if I'm not mistaken. Just looking at the record, and those requests were never agreed to. That's correct, right?
And I do believe I said in the petition that we were invoking the rule regarding post-public comment matters that you can consider because they were not able to be raised during the public comment.
During the public hearing, the hearing officer, whoever presided, did extend public comment by 20 days, right?
I thought it was like 2 days, but I'm sorry, I cannot immediately remember.
Mr. Heister, do you know the answer to that one? I bet DEQ does. Come on up, Ms. Thompson.
Yes, Your Honor. At the public hearing, the hearing officer extended the public comment period to allow for submission of written comments until midnight on November 4th of 2022.
But that was, is it 20 days or 10 days? 20 days? I'm getting, but it's not important. It's my own invocation. Anything else you want to add to this argument, Ms. Thompson? All right. All right, are we done with the adequate notice? Public, go ahead, Mr. Owen, I'm sorry.
It was 2 days.
2 days? He extended it by 2 days.
Yeah, right. It's from the second.
Okay, thank you. All right. we've been going for an hour. Why don't we go ahead and go off the record for 10 minutes and then come back and press ahead. We're off the record.
It's not her. It's not.
Yeah, that's capital. Oh, you know, they got new trucks down there. They kept everybody on. Oh, well, they go down.
So they will be there.
Yeah. You know. So they check. Share it on. She'll be there. Yeah, I think exactly.
Yeah, my friends.
Okay. Yeah. Yeah, that's not the same. Yeah. I don't know if that's on. It's also like, oh, you guys.
All right, folks, if you're ready. And we're back on the record. Next issue that I have here is I've got a title, failure to consider public comments in violation of Rule 22.607. I think both Mr. Mays and Mr. Nolan might have raised this one. I'm a little bit confused about this one though, Mr. Nolan, because and maybe you're arguing both things. As I read your motion for summary judgment, I think your argument was that the division failed to respond to comments because they didn't include specific conditions in the permit to address the variety of nuisance claims that were commented on by the public as well as the city? Or is it that it was a twofold? They didn't respond to comments and they didn't include conditions, or is it just they didn't include conditions?
Yeah, both, Your Honor.
Okay.
I mean, the issue is just as you've said it. We had dozens and dozens of comments regarding nuisance conditions, yet the end product, the permit and the conditions imposed therein made no changes. I mean, we have one special condition essentially that was added regarding additional monitoring wells based on the results or as a result of their investigation regarding the dye testing. That, of course, will not prevent pollution, but only find it after it occurs. But it's our contention that the comments were not properly considered, that the existing permit that does not, as evidenced by the comments, does not properly protect against litter, fire, odor, and these matters that were raised in the public comment period. And therefore, there should have been additional changes and conditions imposed in the permit.
But everything that you're arguing about doesn't relate to this new class 4 cell that was being permitted. It relates to what's already there, right? I mean, you can't have a nuisance or nuisance conditions on something that hasn't occurred yet, right?
Yes, so the operating requirements, other than the monitoring well, are essentially the same for the previous cell versus the expansion cell. So we have no reason to believe that those conditions are protective of the 22.607 factors.
Well, doesn't that beg the question, Mr. Nolan? You can have all the special conditions in the world, but if you don't have parallel enforcement of those conditions, they're meaningless, right?
Wouldn't it be good to prevent those conditions in a permit? And is
Well,
that what 22.607's purpose is?
It is, but I mean, it's already in the rule in terms of it's incumbent upon Vista to operate in a manner that's not a public nuisance. And then it lists things that would constitute a public nuisance. Is there a specific comment that you are relying on that is indicative of this point? Because you pled it in your motion for summary judgment generically. It's like they didn't respond to comments, but in looking at the comments, I can't tell exactly which comment or comments you were referring to. As you said, there's a lot. There's a lot. So you were specific with your argument on the mayor's comment in the resolutions, but these other comments that you're complaining about the argument that the way you've played it was a generic fashion. So is there a specific comment? I shouldn't say that, except for the water well and the allegation that there's some sort of a conduit or preferential pathway in this new cell that's being contemplated. What was wrong with the response to that one?
It's our contention that it's clear that pollution to the surface and the groundwater is going to occur, and that the special condition only imposes monitoring, not prevention.
Okay, so do you have an expert that's going to testify that this condition that was enacted is insufficient to be protective of waters of the state?
We have not identified such an expert.
All right, thank you, Mr. Mays.
Your Honor, we claim that the agency has failed to respond to comments that had to do with the operation of the landfill in accordance with the terms and conditions of the previous permit that had to do with whether they would likely not also comply with those in the new permit. Specifically, let me quote to you a comment that was made to DEQ by the mayor of Tinytown, Ms. Angie Russell, who is sitting here in the audience today. And I'm looking at page 57 of 125 in the comments in the permit. Ms. Russell said, in part, for several years, many citizens of Tinytown have experienced multiple problems being caused by the landfill on Arbors Acres Road. There have been gassy vapors and emitting from the landfill, causing many residents to have dizzy, nauseous, and headaches and other symptoms. I've had it. It happened to me. I'm not talking about the sour trash smell, the leachate smell, or the burning rubber smell. I'm talking about a toxic vapor that's making people sick. And she goes on and on in great detail about people having photographs and other evidence of these problems.
What page you on, Mr. Mays, again? I'm sorry.
Well, the page number is 57 of 125. This is the same passage that Ms. Thompson read to you earlier today about the comments on the resolutions. She also, the mayor also commented about the resolutions, but that's not what I'm talking about here. Now, they were very detailed allegations about problems that exist there at the landfill. And the response of the agency to these very detailed issues and description of properties was simply, as far as that particular issue is concerned, is that Class 4 landfills do not accept intrusible waste, and odor is mitigated through weekly cover, period. In the 50 site visits to Echo Vista in the last 2 years, DEQ has not noted any violations of the Class 4 landfill. That is simply the answer to it. It is not a description of what the source of the problem might be. ADQ is saying here, it can't be the Class 4 landfill because they don't accept intrusible waste. Well, it doesn't have to be intrusible waste to cause a problem. About a week ago, this very same landfill accepted a motorboat with a motor and rubber tires and all that stuff that had been involved in a fire on the interstate that had been taken to the landfill, gasoline and all, and it caught fire in the landfill, in a Class 4 landfill.
Why isn't that an enforcement issue, Mr. Mays?
It's not, well, it is an enforceable issue. There's no question about that.
Right.
It also it reflects either a failure of the permit to adequately provide safeguards and requirements of the landfill operator to more closely scrutinize the waste that goes in there. They're assuming because there is a restriction on protrusible, non-protrusible, on protrusible waste going into that landfill that they're in it. That's simply not true.
Well, but Mr. Mays, okay, so let's carve this up a little bit. I'm not disagreeing with anything the mayor alleged in her comments, right? But this particular comment, absent the resolutions, which is also part of it as well, has to do with what's on the ground now, what exists as far as the landfill, right? It doesn't have anything to do with the expansion of this class 4 cell. It can't because there's nothing going on in the class 4 cell, right? They're not disposing of waste, or they weren't disposing of waste, certainly when she made her comment. So I'm having a difficult time establishing a nexus between an enforcement issue at the existing landfill and a substantive comment about what's problematic about this particular cell and this expansion, except I understand the issue of the preferential pathway and the conduit where the dye test ended up in a nearby creek. So I'll ask you the same question that I asked Mr. Nolan. Do you have an expert that's going to testify that what the division has enacted, because they did enact a special condition related to that what the division enacted is insufficient?
We're going to have witnesses who will testify that the landfill is putting material in the class 4 landfill that is not supposed to be there, not permitted under the permit.
That's apples and oranges, Mr. Mays.
That
It's an enforcement issue of what's existing there right now, and this is a permit appeal of an expansion. Again, I'm not disagreeing with you. The commission has seen the pictures. We've seen the complaints. The city and the residents have been coming to the commission for, she's probably pretty close to 2 years to complain, and we've seen plenty of photographs and slides and everything under the sun related to what's going on there now. But in terms of this particular cell and this particular expansion, I look at it and I think and it just appears to be apples and oranges. And you can argue that you can enact all the special conditions under the sun, but if they're not being enforced, what does it matter?
Well, but the conditions that existed under the previous permit, and this is simply an extension of that permit. It's not something that they're creating a new cell, but it's an extension of the old cell. Presumably, they're going to continue to operate in the way that they have been in the past, which has not been in compliance with the terms of the old permit. And you can indicate that's an indication they're not going to do any better under the new permit, unless there are additional provisions in the new permit that require a stricter management system, a stricter control. And that's what this is about. The comments can go to the question of the regulations that control the daily operations and management of the landfill. And that's what this is.
So what you're saying is, well, again, I can't quite tell. You're arguing that the response to comments were insufficient. That's number one. And B, we're obligated to enact special conditions to address comments in terms of 607, correct?
The regulations say that the commission may require whatever conditions and restrictions in the permit that they believe to be applicable.
Well, I think you hit the nail on the head, Mr. Mays. The regulation says may,
Yes.
right? It doesn't say
Well,
shall.
we're suggesting they should. Yes, we're suggesting that under the comments say under the conditions that have existed there, which you can consider to be their normal operating procedures, that is not adequate, that they will not be adequate under a new permit any more so than they were under the old one, and that the commission require additional restrictions and additional safeguards to prevent this ongoing problem from continuing to occur. They don't know what's causing those odors. I say they, being Eco Vista, they spray it with a chemical that's worse than the problem. And
So you're wanting me to bootstrap everything under the sun to this class 4 expansion. And you're arguing that the rule allows that.
I'm arguing that you can use their past conduct and their past experiences in requiring additional conditions, ADEQ requiring additional conditions, requiring tests to be done to see what's causing those odors and what they should do about it, and report to the agency. They can do tests out there to see what's causing those odors, hire a consultant, report to the agency, let the agency make a decision, hopefully in consultation with the citizens who are affected by this, and impose additional restrictions on the operation of the landfill. That is certainly contemplated by the rules and regulations of the commission.
That's within the four corners of the authority of the permitting agency, right?
Yeah,
So,
it's my understanding.
but the commission's not the permitting agency, we're the reviewing
The
agency.
is, but the agency can, I'm not talking about the commission itself requiring making decisions about what additional conditions and restrictions should be applied. The agency should do that, and the commission should approve it if they do it, because the current operation out there, the current mode of operation is not satisfactory. Everybody talks about how bad it is. They have fires out there regularly. They have continuous odors that make people very ill, that are unhealthy. They apparently have some potential leachate leakage from the facility. Those things need to be studied. They need to be studied at the expense of Eco Vista, but with a contractor of ADEQ's choice. And then there need to be some additional restrictions or requirements placed on Eco Vista to operate in a better way in order that these problems won't exist. It's causing a huge problem for the people who live in that area.
What would the special conditions be?
Well, Your Honor, I'm not an engineer.
Neither am I.
And I would not begin to know what special, but somebody does. There are people who can be hired to go out and do a study of what's causing these odors. That's one of the first things that needs to be done. And what's causing these fires. They're not operating the way they should be. They're letting material get into this class 4 landfill that is causing a lot of these problems. And they need to be doing something about it. And there are people who know what should be done about it. I'm not one of them, but there are people who could be hired to find out.
Have you retained those people?
How do you retain them?
Have you retained them?
Oh, no. I don't have the money to retain them, Your Honor.
All right. I haven't retained them either.
Well, that's why we're asking.
And without some expert opinion elicited, I'm just grasping at straws on this.
Well, and you know, that's this is not a summary judgment issue, and in my opinion, I don't.
Oh, it is because Mr. Nolan moved for summary judgment on 607, arguing that comments that were raised that erred because special conditions to address these comments weren't included in the permit, in the class 4 permit.
But I don't know.
The problem I've got is I don't know what they are. They haven't been articulated. There hasn't been an expert affidavit attached saying, here's where the division messed up, or here's where Eco Vista messed up. They should have included these conditions as part of the permit. I don't know what they are. I don't know what's missing. And there's a huge gap of information in terms of what it is that you want. And then I'm left also with the issue of the rule doesn't, 607N is not a mandatory rule. It's a may rule. I mean, the division may include special conditions. It's not required. So you're asking me to
I'm not.
I guess just remand it back to the division and say, what you've done is insufficient. I don't know what it is that you've done that's insufficient, but you need to do more than what you've done. And it's a may, it's not a shall.
I'm not asking for a summary judgment on this. I think it's a
No,
fact.
Mr. Nolan is.
Nolan is, and that's fine. I wish him all the luck in the world. But I think that there are factual issues that need to be developed here in order to answer the questions that you and also I have about it, because we obviously can't solve the problem. There is a huge problem there. And if this problem would go away, and something can be done about it, I would imagine, if it goes away, then a lot of the problems that Echo Vista and my clients have will go away. But we don't know what that is at this point. And I don't think that it's right for summary judgment for either side. I think there needs to be there are factual issues that are in dispute.
How are you going to prove it up at an evidentiary hearing if you don't have experts to testify?
Well, Judge, we'll find some technology.
I think it's a little late.
Or there may be some way of doing that, Your Honor. I think it's a factual issue that the people can testify to, and let them tell what the problems are, and maybe the agency can come up with
The
something.
people have already said what the problems are. I understand that. That's plain. I mean, you can just read the comments and you can see what the problems are and what the complaints are. The disconnect, the gap is, first off, what does that have to do with the class 4 expansion? And then secondarily, what are the solutions? All you've got are complaints, but there's nobody that's testifying what would solve it.
Solution would be a tighter control of the operation of the landfill by the agency.
Okay.
I mean, I don't know how else you do it. And to a great extent,
Well,
it's a self-policing operation. It more or less has to be, but they have to follow the rules and they should follow the rules of the permit. They're not doing that. There needs to be some way to figure out that the agency can figure out, along with whatever suggestions we may have to offer to do that.
so again, the motion for summary judgment was this, Mr. Mays. The division's response to comments were insufficient, all right? Except for the one comment that Mr. Nolan raised in his motion for summary judgment about the mayor's comment regarding the resolutions. That's the only specific comment that was pled in a motion for summary judgment. The other one is just this generic response to comments were insufficient. There's a ton of comments in there. I'm not certain which ones were sufficient and which ones weren't. That's number one. And then number two, I've got a rule that says may in terms of special conditions. Mr. Nolan has said that there are not sufficient special conditions in this permit to address those complaints, except I don't know what they should be. Nobody's offered me any kind of evidence, solution, affidavit, testimony about what the division did, what the division did was problematic or an error, and what they should have done. And I'm not the permitting authority. The commission's not the permitting authority. I hope you understand the hurdle that I'm having here. Okay. All right. How about this? Who wants to go on this one? It doesn't matter to me. Ms. Thompson.
I'll keep it brief, Your Honor. In DEQ's motion for summary judgment, we also did argue that DEQ adequately did respond to the comments pursuant to Rule 8.211A2. We responded to the comments. We looked at all of the comments. We responded to all comments based on the Class 4 landfill expansion and the solid waste management rules. There were multiple comments about odor that I talked about in our summary judgment motion. And with specific condition number 4, relates to cover. Under the Solid Waste Management Act, the main way to deal with odor is through cover. We have that in specific site-specific condition number 4. I have an example of a comment that I added on page 18 of our summary judgment from a commenter by the name of Tammy Graham, who commented by stating, quote, "We are not gullible enough to believe anyone will be checking the trucks, loads to assure only that bricks or scrap lumber is being hauled in, since class 4 landfills are only supposed to take bulky waste. Most of it's supposed to be C&D waste." We responded, and our response is on page 73. It was attached as exhibit number 18. The response was that DEQ inspects Echo Vista quarterly. We inspect all landfills quarterly, the inspectors do, and in response to each complaint to determine that only permissible wastes are placed in the landfill. And the landfill performs random load checks and checks the load once it is placed at the working phase. That was our response to that particular comment regarding odor. Now, some of the comments regarding gas, noxious fumes, there's a very limited section of Rule 22 that deals with air criteria. Most of that would be dealt with under the Title V air permit that Echo Vista has regarding that part. So that's not even relevant to this matter today
So
regarding the class 4.
let me ask you this, Ms. Thompson, if I could. So looking at the permit, there were a number of
Yes.
conditions associated
Yes.
with it. Was Mr. Nolan said only one condition was included or enacted in response to a comment. Was that the conduit, the preferential pathway that was discovered through the dye test?
The monitoring wells, the
Yeah.
groundwater. I believe that the class 4 Echo Vista landfill, I believe this, it's the only one in the state that has monitoring wells, has groundwater monitoring wells. I believe that's an accurate statement.
Okay, so
Mhm.
so was that included
Yes.
in response to that comment, or do you know? And I mean,
I
it's
don't
not a
know off the
test.
top of my head. I didn't bring,
I don't know off the top of my head either. That's why I'm asking. I know that there were a bunch of conditions associated with it. But again, in terms of this expansion in this particular cell, that was the one that, at least looking at it, troubled me the most because it was specific to this location. It was specific to a future expansion. It's specific to this operation of this particular cell. So I was, again, curious as to whether or not those conditions, the monitoring wells, I think there's a leachate collection as well. And then I'm not certain, I can't remember the components of the liner that are going to go in, but it seemed to me to be a little bit more belt and suspenders than what I had seen in the past in terms of groundwater monitoring.
that's correct, since the dye trace study showed the conduit. So they want to take they're taking samples from that to make sure that nothing gets contaminated. They're following that.
Off the top of your head, again, not a test. How often are you taking or requiring activists to take groundwater samples? Do you know?
Right off the top of my head, I do not know.
Not a problem.
Yeah.
All right. Anything else? Thank you, Ms. Thompson. Mr. Heister.
Just a couple of quick follow-up points, Your Honor. We're here today on summary judgment. That's been state law, but what's gotten lost in that is if there's proof, if there's evidence, this is the time to lay it on the table. It's not to save it for a hearing. I'm reading from New Bern Civil Practice and Procedure. Once the movement makes a prima facie showing of entitlement to summary judgment, and specifically, I mean that with respect to our motion to DEQ saying they have no evidence to support their claim, the burden shifts to the party opposing the motion to show that there's a genuine factual issue for trial. And all the lawyers' arguments about what people are saying or how the community feels is of no value on summary judgment. The court actually does have in the record references to the enforcement file, permitting file for DEQ, and for all the complaints that supposedly occur for all these issues. Where is the evidence, the actual proof that the court can on summary judgment to support any of those actual claims. Where the charts, where the summaries of enforcement actions taken, none of it's in front of the court today. And they can't show up at a hearing with it. It's today, was in the papers that have been filed, or never. And there are no engineering experts to tell the court what to do. There are no doctors to tell the court these people complaining about odors are actually suffering any sort of medically cognizable symptoms traceable to anything that's at issue today, or even the landfill as a whole. So there's a complete failure of proof here, Your Honor, on summary judgment, and if there was going to be that proof, now is the time. So summary judgment is appropriate for Ecovista and DEQ.
Thank you, Mr. Meister. Mr. Owen? Yes. All right, Mr. Mays, I think I've addressed the two things that you raised in your motion for summary judgment, which was public comment and then the certificate of need. I think I've covered everything in yours, Mr. Nolan, except of course, we're getting into the heart of the matter. We've been picking around the edges of this all morning long. So let's gravitate into the resolutions. Wait a minute, I did forget one. I apologize, Mr. Nolan. There was the one about not considering an alternative location. I think you raised that in a motion for summary judgment as well. Did you not?
Yes, very straightforward motion. ADQ is unsure whether or not it is applying 22.204 to this case or to this permit. And it's my contention that you can't issue a permit if you don't know what laws apply. Their discovery responses make it clear that they were unsure what they were doing in regards to 22.204. And so it is unclear to me how they can then turn around and issue a permit without determining the applicable law. That is as straightforward as I can be. That is arbitrary and capricious. And, we have to know what rules are being applied and what we are appealing. So that is that argument, Your Honor.
So, okay, so you cited 22.204A. That says, in accordance with Arkansas Code annotated 8-6-1501, a rebuttable presumption exists against permitting the construction or operation of any new landfill within 12 miles of any existing high impact solid waste facility. And then the presumption may be overcome, and it goes. So I looked at this and it appeared to, just at first blush, that it applied to the siting of a new landfill. And this is an expansion. Now, granted, at the tail end of 2204, it talks about the division shall not process any pre-application for a new or increased landfill acreage or an application for increased landfill capacity until definitive findings in conformance with the section have been provided by the host community, accepted by the division. Acceptance or denial of the landfill siting by the host community shall be a formal resolution of the governing body of the host community. So I guess the argument that I would have would be, if the host community has withdrawn support, why does the division even have to do an alternative analysis?
I'm saying the division needs to determine what rules it's applying to a permit before it issues the permit.
Okay.
I mean, it seems beyond arbitrary to me that you would have a permit before determining what standards you were applying to it. And we have to know what it is and the basis. And we've cited case law, towards the end of our brief, that, they have to articulate, an agency has to articulate the basis upon which it is issuing a permit. So did they or did they not issue this permit partially upon compliance with 22.204? And we just don't know from the record. I mean, they need to figure these things out before they issue a permit.
I'll grant you that.
Well, then we ask for summary judgment on this matter.
Well, the question is, did they analyze it? Because, boy, it seems like there was a bunch of back and forth and discussion, looking at the record. I know that you pulled a response to an interrogatory as a request for admission.
Interrupt.
But at least in response to that discovery, I gather at one point they thought 22.204 did apply, and somewhere down the line something changed, right?
I mean, I wish it was clear in the record, and then we would know what we're dealing with.
Well, I think it's pretty clear in the record that everybody was going through the motions to comply with, certainly with 204.
I'd say certainly.
Yeah, maybe 204. I mean, otherwise there wouldn't have been host agreements, aplenty, amendments to said host agreements. When the pre-application was submitted, DEQ did not say, why do you get host community approval? Because it's not necessary in the 22.204. That never happened, right? Okay. But something changed between when the application was provided and after this request for hearing was filed. Or you don't know the answer to that.
I mean, in the 30B6 deposition, I asked repeatedly how 203 and 204 were considered and where that record is. And as best I can tell, it was not, the applicability was not considered. And I mean, that's.
Yeah, Mrs. Weifel, again, we're back to a legal analysis. What's the legal import of the city passing the resolutions that it did? He might have been uncomfortable with giving you a legal analysis, or it may have been above his pay grade in terms of the legal perspective. I don't know.
I mean, we have to stop right there. When I'm doing a 30B6 deposition and I'm asking that witness questions, those are binding statements on behalf of the agency, and I have to be able to rely on those to move forward in the case.
Okay.
And Ms. Thompson objected multiple times on asking for a legal conclusion. And so, I mean, I backed up a little bit and I just asked for the existence of whether or not they considered these issues. And I think the answer there was still no. I mean, that is not a legal conclusion. That is just whether or not something happened. And I don't think it happened. I don't think before issuing the permit, they considered the import of 203 or 204, and that is not articulating basis of the permit. That is not articulating the basis of the permit, and that is their job.
So is that a fact in dispute then?
Is it a fact in dispute?
Yeah.
He said, no, I don't think so. I don't think they did it. I don't have any indication that they did, that they made any consideration of 203 or 204. And I think they did that and issued the permit without making up their minds on what the import of the resolution was or whether or not 204 is applicable. That is arbitrary and capricious.
All right. So let's take it a step further. You have, well, no, we'll drop it because we're kind of far afield in terms of the alternative location issue. Mr. Rubin, it looks like he's getting ready to jump out of his seat. Are you the alternative location guy? Come on up here, sir. It's Mr. Mays, I apologize. I skipped over you. Anything you want to add to that? The alternative location? Go ahead, Mr. Rubin.
Okay. So if I'm understanding the issue that we're trying to frame here is whether or not the division had a duty to consider alternative locations.
I think that's the way it was put in the motion for summary judgment.
Okay. So as I read both the rule and the statute, the duty to consider alternative locations comes up in response to rebutting the presumption against the siting of the high impact solid waste management facility. So whether or not the statute and the rule apply is pretty germane. If they don't apply, then it is necessary to move on to the next step of whether or not there is host community approval, either explicitly or impliedly by showing the existence of incentives, or in the alternative that there is no other suitable site. So I want to emphasize that the finding of whether or not there is a suitable, no other suitable site would be one of two ways that this could be lawfully permitted if express host community approval does not exist, and if the high impact solid waste management facility statute applies. So when we answer our discovery under legal objection that we're not entirely certain whether it applies, we're only saying it's certainly possible that it does not apply. It could also apply. And I believe we have fleshed out very, very generously in our summary judgment motion and in our replies as to what are all the possible applications of the rule and the statute.
Let me stop you right there. So you didn't raise this in your motion to dismiss. Why didn't you raise it in the motion to dismiss?
I am not certain why we didn't raise it in our motions to dismiss.
Was there something that occurred between when you filed your motion to dismiss and your motion for summary judgment?
I certainly can't recall any specific instance where this came up. Was there, how about if I put it this way, Mr. Robinette, was there an evolution of understanding on behalf of, I'm certain it's not on behalf of the individual divisions, but on behalf of the legal division about whether or not host community approval was necessary or required? What do we got here? We got 203 local authority approval at site collection and expansion, and then 204 host community approval at site selection. Those to me seem to be pretty straightforward legal issues. And I am curious why they were not raised in the motion to dismiss. Well, I don't recall what our deliberations were on the issue. I think that probably as we looked at it, we probably began to see different facets of the issue that could be looked at. I mean, at the outset, I want to point out that this issue would be a part of the pre-application process. So if facially it appears that we have that approval and it is in the pre-application, the permitting process begins. So at that point, there's really no further consideration or analysis. The permitting process has started.
You got host community approval, you got the documentation. There wouldn't have been a need at that juncture to go through some sort of an in-depth analysis about whether or not host community approval was required at that point.
That's right, Judge.
But I'm going to go under the assumption that at least the folks in legal over at Vista, or the legal representation that they had, looked at the rule and determined that it was required, because they wouldn't have gone through the process that they did, negotiating with the city and giving concessions and entering into these agreements if they didn't think it was necessary. Would you agree with that?
And if I'm understanding your statement correctly, that all of the, and when you talk about the negotiations, are you talking about the?
I'm not, look, I'm just looking at the record. There seem to be various iterations of a host agreement. There seem to be amendments to it.
Yes.
There was email chains that were submitted as part of the record where, and I'm paraphrasing, someone from I think it was legal with Vista looked at it, or maybe it was the city attorney, I don't know. But somebody with a legal perspective looked at it and said, everything's done. All the T's have been crossed, all the I's are dotted, nothing more is needed. This this is ready to go and ready for submittal as a pre-application.
Yes, it
Okay.
seems like that was very well developed between Echo Vista and the city prior to the submission of the pre-application.
Right.
On
Okay.
the record, yes.
So somebody from the city at one point at least was under the assumption that post-community approval was required and necessary too.
It does seem that way, Judge
Yeah.
Mulder.
Okay. All right. I apologize for interrupting. Is there anything else you wanted to add?
I don't believe there was anything I wanted to add, just to
Okay.
emphasize that this is a pre-application requirement, which we
Right.
received. We looked at, we proceeded with the application.
We kind of gravitated away from the alternative location.
Yes.
So while I have you up here then, I've read the briefs. And so let's look at 22-203, local authority approval of site selection and expansion. Reading this, I think I understand the division's position that 203 does not apply because there's not a countywide land use plan or a citywide plan.
This, yes.
Both.
So this is quite a situation, Your Honor. You know, the rule says countywide land use plan, but if we look at the statute, and the undergirding statute of this rule is 86209. And that says a fully implemented comprehensive area-wide zoning plan and corresponding laws or ordinance covering the entire municipality or county. And this statute speaks to whether or not a municipality or county may adopt standards for location, design, construction, and maintenance of solid waste disposal sites and facilities more restricted than those adopted by under or pursuant to the Solid Waste Management Act. So for whatever reason, the rule says countywide, and I think it's probably should be area-wide. And so a lot of briefing was spit on that, a lot of ink spilled. But if you look at our response, I believe maybe the last thing we filed, we did discuss this as to whether or not if in fact we had a valid citywide zoning regime in place. And from the record, from looking at the ordinances that have been filed in the record, well, resolutions as well, some are resolutions, some are ordinances, in particular the zoning ordinance that filed, which showed this property, which had been previously annexed by the city of Town, had a zoning something like MH for mobile homes and also for residential. So while there was a land use plan in existence, the land use plan was certainly not fully implemented or comprehensive because there was no landfill use established under with their ordinances prior to rezoning the entire property. So at the time of the pre-application, there is no existing use landfill, no landfill use in their plan or implemented from their plan. So
When you say their plan, are you referring to Washington County or
the city of Tontitown.
Okay. Okay.
Washington County has no ordinances governing solid waste at all.
Well, they do have
Well,
countywide, I think they have countywide zoning. I say that based on a note that I just had recently, where the county's zoning land use. Well, let me ask you this. What's the difference between a land use plan and zoning?
oh, well, so the land use plan would certainly speak to zoning and the various classifications and uses of property.
Okay.
Zoning itself is a particular implementation of the plan. So remember, the statute says it must be comprehensive and fully implemented. So our position would be that at the time of the 2018 ordinance, because there was no fully implemented plan, this authority under 86209 to make any sort of restrictions on the site use just wasn't there. Now, granted, they gave it, and that's great, We looked at it in our pre-application. We started the permitting process. But if we want to get back to it, it maybe wasn't even required in the first place.
So let's see if I understand this. It's DEQ's contention that there is no city land use plan or zoning or both.
Not at the time of the pre-application.
Not at the
that
time of
would-
pre-application.
Not that would
Okay.
cause 22-203 to be applicable, but I point out, not only is that the case, but they gave at least a facial approval to the location of this site at the time of the pre-application. But of course, Judge Moulton, this story gets more complicated as we progress, but going back to the time of the pre-application, we did
Right.
nothing wrong by accepting it and moving forward.
Well, okay, so I'm going to go under the assumption that there was a Washington County plan, land use plan, maybe even zoning from the perspective of the county. But that's apples and oranges because we're looking at what the city did or did not do in terms of their resolution. So you're saying 203B is not applicable, but C is. And when the pre-application came in, Tawny Town didn't have, oh, wait a minute now. No, that's not right either. Hold on a second, Mr. Rowan, I might be. Okay, so now I'm really confused. I'm looking at 203. And all it talks about is a countywide plan
That's correct.
and regional standards and rules.
That is correct, Your
All
Honor.
right. So there's not even a mention of whether or not Tawny Town was required under 203 to have a land use plan or zoning, whether it was pre-application or post-application.
Certainly true. That's what the
Okay.
rule says. But
So, and it talks about both B and C. It talks about conformance with countywide plans and conformance with regional standards and rules, and then conformance with other requirements. I guess you could argue that D, conformance with other requirements, might fall into the envelope of the city's land use plan and or zoning if it had existed at the time of the pre-application.
and perhaps if that is the case, Your Honor, then it might be a moot point. I don't believe D was even argued. I think only B was argued.
You may very well be right about that, Mr. Rowland, and I don't know for a fact whether or not that was the case. All right, let's focus on B for a second.
Certainly.
So again, I think there's been an argument that Washington County has enacted a countywide land use plan, zoning, whatever. So you could potentially argue that B might be applicable, right? Or maybe there's a fact and dispute about that.
I do not believe
But-
that there's a fact and dispute, Your Honor.
Okay.
I think it's an application of law, and I would point out that as far as compliance with 22-203B, it's a pre-application, that is the timing of it. The, as you can see in the last sentence, shall be by applicant for submission to the division with the pre-application. What we have is the 2018 ordinance, which I think is 07797R, which says they set forth the specific approval of the specific geographic location of the landfill. So wiping aside any of the other legal arguments about the statute or anything else, there it was in the pre-application. So we did our job. We looked at it, we saw it, we started the process.
Look at E, 203E. What does that mean to you? Sure. What does that verbiage mean to you?
Well, I think it's very clear. it says the approval or denial by local governments shall be in writing, shall state the basis for the approval or denial with reference to the specific requirements of the local jurisdiction in this rule.
So is 203 basically a rule that's in place that if a county or a city or whatever municipal entity you want to apply it to, a town, has some sort of zoning and or land use plan that would prohibit the expansion or prohibit the location or something of that nature? The way I understand or read this rule, and I can be disabused of the notion that that municipality, the entity that's trying to expand a landfill, create a landfill, site a landfill, goes to that municipality, that entity, and that entity says, you can't put it here, or you can't expand it here because it violates this specific land use plan, or this provision of our land use plan, or this provision of our zoning. Am I missing the boat on that? Is that what the rule 203 is intended to do?
So certainly the 22203, its statutory companion authority is 86209. The point of 86209 is to not allow local governments, counties and municipality to arbitrarily exercise, well, let's just say the General Assembly found that, I believe in enacting this, and I talk about the act in the brief,
Right.
that the allowance of local control was seeming to hold up the ability to provide essential services such as solid waste. So they enacted this law in order to allow a county or municipality to make restrictions on location, design, construction, and maintenance of solid waste disposal facilities. Only if, and there's a big unless in it, there has to be a fully implemented comprehensive area-wide zoning plan and corresponding laws or ordinances covering the entire municipality or county. So what this rule speaks to is if the rule speaks to the statute, that's our authority, is that if this jurisdiction that is hosting this landfill or has this landfill within its jurisdiction, if they have this fully implemented comprehensive area-wide zoning plan, it's been enacted with laws or ordinances, and it covers the entire municipality, they may make more restrictive laws than the state. And that's what it's there for. And so in a part of our permitting process, as a courtesy to this jurisdiction, which may have concurrent jurisdiction with us, if they have met all the requirements, we make sure that our pre-applicant has obtained that consent or is legally allowed to place that landfill there under the zoning laws that are applicable to the locality. I believe that is why this rule is there.
Okay, I don't necessarily disagree with you. The resolutions that the city enacted withdrawing support doesn't specifically reference a land use plan or a zoning violation or anything that had been passed by the city, by the county, by whatever, that would prohibit the expansion of this class 4 cell, correct?
Correct. And to the contrary, the
Are they-
resolution itself. and I'm
Under
sorry, I don't
E,
mean to talk over
under
you.
E, are they required to do that?
I'm sorry, sir.
Under 203E, is a city or municipality required to do that, required to provide specific information in their withholding of authority to expand? Because as I read it, it says, and again, I could be wrong, it says, any approval or denial by local governments or regional solid waste management boards or solid waste site solid waste site selection shall be in writing, which we have the resolutions, two of them, and shall state the basis for the approval or denial with reference to the specific requirements of the local jurisdiction and this rule.
Okay.
So I take that to mean that a local government can withhold support for the siting of a landfill, the expansion of a landfill, but they have to bootstrap it to a zoning or land use plan or something that prohibits that expansion or that siting from taking place. Am I missing the boat on that?
Well, to your point, sir, I believe that would have to be exercised under some sort of valid jurisdiction that is concurrent to the divisions or the departments. And that would have to come from what the General Assembly has bestowed on them, which I've read to you in the statute. And so, yes, I believe it would have to be related to either the granting or the revoking of zoning, and why or why not.
I'm going to go under the assumption that, and again, this is an assumption that the county, local government, the city, somebody has some sort of land use plan in place, zoning in place. Certainly when they passed these two resolutions, I think there was land use plans, zoning in place when the withdrawal of support took place. Again, I read this and it seems to me that they would have had to have cited to a potential violation of that land use plan, that zoning, in order to properly withhold their approval.
I would agree that it would be necessary for them to somehow revoke that zoning. And yes, or perhaps if the implemented plan existed, if there is some aspect of the facility that they're building that is within that plan, certainly it's possible they could cite to some specific provision within their zoning and land use plan or about it. And some of it has to do, and we go back to the statute again, it's about location, design, construction, and maintenance. So it's possible for them to enact that within their zoning plan. So since we're not dealing with maintenance, or possibly we could, but I guess Judge Moulton, what I get to is that this is a completely different, this is a different jurisdiction that they have over the landfill. It has nothing to do with us. If you look at the Arkansas Soil and Water Conservation Commission case that was provided in our brief, it acknowledges that administrative agencies and municipalities and counties are all creatures of the state, and they may have different powers bestowed on them. They have their own lanes that they have to be in. And I believe DEQ stated its lane here. We issued a lawful permit. We had everything facially at the time the pre-application is required by our rules. And what the city seems to be asking us to do is to enforce their laws, which we can't do. If you look at the Soil and Water Conservation Commission, it's made clear we can enforce their laws and they can't really enforce ours.
Well, I don't know about that, Mr. Robin. I don't think they're asking you to enforce their laws. I don't even know if that's the case, then you'd have to point out to me what law it is that they want you to enforce, because I certainly haven't seen that in the record in terms of enforcing whatever ordinances or zoning or whatever disconnect that I'm having. Well, let's take a step back.
Sure.
I know that you're focusing on pre-application, but the reality is the clock doesn't stop when the pre-application, everything doesn't just cease to exist. Pre-application, until you make that final permitting decision, that it's still open. And I know that the division will accept new information, different information, something that may impact their final permitting decision within that window, right? So, I mean, just because it was pre-application, things change, conditions change. Sometimes the permitting decision itself takes an extended period of time. And I know the division is always receptive to wanting to make certain that they get their permitting decision correct. So they look past the permit application timeframe. It doesn't stop there. So if things change, things are altered, conditions change, new information comes in, that's looked at, that's analyzed, that's assessed. It's part of your permitting decision. I'm fairly confident that the division looked at these resolutions, correct? And I'm fairly confident, based on what I've seen in the record, there was an evolution that took place in terms of when the permit application came in and when the final permitting decision took place. Is that correct?
Oh, yes.
Okay. So there isn't any definitive cutoff point except when the permitting decision theoretically takes place. Although frankly, it seems like maybe even after the permitting decision took place, the division's thought process on 203 and 204 continued to evolve. Is that correct?
Certainly, there were things that other facets and aspects and dimensions of the statutes and the rules that we had to think of and consider. I mean, that's just part of the deliberative process of being an administrative agency.
Are there facts in dispute over, at least from your perspective, over the applicability of 203?
I believe there are no facts in dispute. I believe.
And if there were a fact in dispute, would it involve the zoning land use plan, the existence or non-existence of said plan?
Well, Your Honor, I think the record amply demonstrates that as the permitting process went on, not only certainly our legal thinking, our consideration of things changed, so did the city's. Along the way, the city granted Echo Vista an exclusive use landfill zoning, sometime in 2021, I believe. And that zoning, as far as I can tell, remains in place today. And when we received these resolutions of November 22 and January 23, there was no indication in any way, shape, or form that zoning was revoked, or that there was any aspect of those zoning laws that were being invoked to stop the permitting process. Well, not stop it, but I suppose to bring them out of compliance. The resolutions, I've read them many times, and they seem to be a general statement that the city no longer supports the landfill. Now, it doesn't say that the city revokes the landfill zoning. The landfill is in violation of these city codes, and therefore they're not in compliance with 22-203. They were very, very broad statements about revoking support and what does that mean. And I think there's no dispute that there is no legal force effect or meaning to this. It's just a very plaintiff cry and the notice and comment rule making process, which was considered and deemed to not hold up the permitting process.
All right, thank you, Mr. Robin. Anything else you want to add or no?
And I'm not certain, Judge Moulton, we've gone on quite a ride here. We've talked both about zoning and host community approval, but they are discrete issues.
Yeah. Let's just focus on 203 for the time being, and we'll get to 204.
Yeah, I think we might have veered into 203, but certainly I'll be happy to come back for round two on 204.
I appreciate it. Thank you.
Thank you, Judge Moulton.
Yeah. Hold on, Mr. Miller. Let's hear from Mr. Heister first, because he's moved for summary judgment on this one, although you all have. We'll hear the for and against together. Go ahead, Mr. Heister.
There was a lot of ground covered there, Judge. So I apologize if I'm going to jump around a little bit, but obviously if there are any areas of special interest to you, let me know. With respect to Rule 22.203E, in order to proceed under that, the city would have had to have had a denial with specific requirements of the local jurisdiction in its denial. And it's obvious on the face of the document in the record, there are no specific requirements of the jurisdiction acknowledged in that document. So putting aside the fact they didn't proceed under that, so they don't have that argument in the first place, even if it were considered. They're kind of victims of their own argument here insofar as they take DEQ to task for not providing enough detail with respect to some things. And here, where they had an obligation to act in a specific manner, they failed to do so. And Your Honor, that's important because they're a government agency too. And if they're going to take these sorts of legal steps, then Vista is entitled to hold them accountable for that in a court of law. And so they have just as much obligation, if not more, because here, unlike, I guess, Rule 8, which is somewhat loose as to how much detail the DEQ actually has to provide, here the rules quite specific. The city had to provide references to specific requirements. With respect to 22204B, I understand the court to say that you're aware of a countywide, because it wasn't clear whether it was a zoning ordinance or a land use or a comprehensive countywide land use plan in existence in Washington County. One of our arguments was the petitioners here, being the parties with the burden, they wanted to rely on 203B, had to show the existence of such a plan on summary judgment. They failed to do so, they cannot proceed. Obviously, if the court is aware of such a plan that does exist, that's something to take judicial notice of. However, I have a little bit different reading on 203B, and insofar as we read this as saying that if a municipality or county wants to adopt restrictions on a site, that those restrictions have to be done in conjunction with a comprehensive county-wide land use plan. And that's the reason why the subsection B is titled Conformance with County-Wide Plans. So there's no universe where a municipality can kind of proceed independently on its own under 203B. And taking a step back, I think the implementing statute expresses concern about city saying, well, we don't want this here, and kind of imposing a burden of the commons type problem or whatever it is, where everyone wants cheap solid waste disposal, but no one wants it to be near them. And at some point, government has to step in and say, well, we need this for the common good, for health. And so the rule allows a county or a city to impose those kinds of limitations, but it has to be done as part of a master plan for the entire county, a land use plan, not zoning ordinance. It's a land use plan, and land use plans are traditionally much more specific than a zoning ordinance will say. As of course generally aware, general zoning ordinances, residential, commercial 1, 2, industrial, but it doesn't tell you what kind of industrial is going to be there, or how much road it's going to take up, or parking lots, or anything else. Land use plans.
Let me stop you, Mr. So again, it kind of begs the question for me. I guess I'm a land use plan neophyte. What's the difference between a land use plan and zoning? Do they overlap? Are they separate and distinct?
So land use plans are generally more specific and are kind of usually entered into, for example, what you have here, we have the large scale development plan. I don't want to speak out of turn, but I think that is a land use, the large scale plan, right, be considered a land use plan. And so that's kind of done under agreement with a party that here's what we're going to do. It's approved in a government action, by a foreign court or whomever, but it's different but it's done with respect to kind of specific things. So if a county wants to enact a land use plan saying, here's our kind of goals for the whole county, they're going to need to include somewhere in there someplace to put waste. And maybe that it's not going to be in one municipality or another, but it's not much of a plan if they don't have any trash disposal. It's part of it. And so it makes sense that you can say, yes, a city can impose some certain restrictions if it's part of some broader plan where somebody is thinking about this. It has, and it's kind of considered, okay, what are we going to do? So in a nutshell, Your Honor, that's why we think, there's been no showing that 203B applies at all.
So, all right, so let me just try to distill this down. As I look at 203, there are only certain plans or standards or rules that are applicable. Under 203B, there has to be a countywide plan, adopting restrictions on sites in conjunction with a comprehensive countywide land use plan, right?
Mhm.
So that's number one. And then specific geographic site approval from the governments of jurisdiction shall be obtained by the applicant. That's not really, it's not defined, the governments. I would have thought that it would have said county, but it says government. So I guess that's broad enough to include the city, right? But again, you've got to have a countywide plan that has certain specific geographic approval requirements. If I'm looking at 203B, I don't know if that exists. I know that Washington County does have a plan, but I don't know if it's broad enough to include 203B. But I do know that the resolutions passed by the city never referenced any countywide land use plan, never referenced geographic site approval or anything associated with a countywide. So that one's off the table. And then we have C that talks about conformance with regional standards and rules. That's the Regional Solid Waste Management District. I don't think that was even cited, and certainly not referenced in the city's resolutions. And then we have D, which is the conformance with other requirements. Says as applicable, as you noted, applicants shall also meet the requirements of Rule 22.204 regarding high impact solid waste facilities and 205 regarding certificate of need. I don't think that was referenced in the motions for summary judgment filed by the mayor and the city and the individual petitioners. So I think we were looking at, and I have to pull up the motion. I think what they did was they referenced 203B in their motion for summary judgment. So again, I'm back to looking at the rule. It seems like any kind of a withdrawal of support or denial based on a government entity needs to be bootstrapped onto a plan, somebody's plan,
Yeah.
somebody's, right?
It is plain under the rule that, okay, either you have restrictions or you don't. If you don't, we're not arguing. So presumably they're saying they have some sort of restriction to allow this. And so if the facility is located within a municipality that has adopted restrictions on sites, so we'll assume that they've done that. It has to be in conjunction with a comprehensive county use plan. And that's where it falls apart, because the goal of this rule is to prevent precisely what happens here. That, local municipalities who have very limited legal authority in this realm anyway interfere with the broader management of solid waste whose effects reverberate far beyond the municipality itself.
Okay.
So anyway, yeah, so we're strongly, we don't think that there's been a showing that 203 applies, but kind of in any event, it's clear in the record that since 1997, the city has been approving this site. And I know the site predates that, but I think we can date it we can go from 1997 because we have the clearest resolution, and that's Exhibit B in our motion, where now therefore be it resolved, the city of Tontitown agrees that payment of the reasonable host fee provides a reciprocal benefit for any likely burden caused by and overcomes any citing presumption of Sunray Services Inc., the predecessor to Vista LLC. So even as early as 1997, DEQ has in front of it documentation saying the city accepts this site. And I know we mentioned it again, there's follow-on ordinances. Even if they got over the legal hurdle, kind of the argument on summary judgment that the DEQ didn't have more than adequate evidence of local siting approval, I think hasn't been shown. I guess I would respectfully disagree with one point that was raised earlier with respect to DEQ's kind of continuing obligation. It is unquestionable that DEQ does have the right to always consider new information and revisit its premises throughout the application process. However, the language of 22.203B is clearly a pre-application requirement, and to give that language effect and meaning, it has to be used that way. To turn it into kind of a rolling obligation, it just writes the pre-application part out of the rule, and that's not proper, and it's not necessary because DEQ has other authorities it could proceed under if it felt there was an issue there it needed to address. There's also a kind of a question early on about why some arguments were raised earlier. And it's important that based on the information that was kind of made available quickly after the petitions were filed, there was some question as to whether the city's motion was valid at all. And so consequently addressing in a motion to dismiss all the different arguments of a party who potentially wasn't there and didn't have jurisdiction, jurisdictional basis to raise those arguments would have been premature, especially when those arguments could be taken up on summary judgment. So I don't think there's really anything to take from that any more than taking anything from the kind of the Ecovista's actions with respect to the city as an entity seeking permitting authority from various government entities. Ecovista doesn't have the luxury of quarreling with the government agencies about what regulations do or do not apply. Ecovista was able to say, look, if this applies, we satisfied it, let's move on. And from our perspective, that's a low cost endeavor, because all that does is ensure that you've kind of gone above and beyond what might be lawfully required. And so again, we don't think there's any kind of legal relevance to any of those characterizations in our permitting documents.
Thank you, Mr. Heister. Mr. Nolan.
Your Honor, I'm admittedly incredibly frustrated here because I feel like I'm chasing an amorphous decision. Coming into today, it was Ecovista's position and their motion for summary judgment that what is submitted at the time of the pre-application controls, which of course was the 2018 resolution. And then it was ADEQ's position for the first time that I can find anywhere in the record that 22.203 does not apply at all, which as briefed is contrary to everything I can see in the record. And now today we have from you a new argument that there must be a citation to some specific violation of a land use plan or other decision. And
Isn't that what the rule says, Mr.
No,
Nolan? It doesn't say it.
it says specific geographic site approval from the governments of a jurisdiction. That was granted in 2018 with the resolution. We don't contest that.
I'm going under the assumption that the resolutions happened, okay?
Yes.
It says in 203E, written approval or denial. Any approval or denial by local governments or regional solid waste management boards of solid waste site selection shall be in writing and shall state the basis for the approval or denial with reference to the specific requirements of the local jurisdiction in this rule. I understand that nobody raised it in their motions for summary judgment. I get that. I mean, I looked at the rule way back when and the resolutions when the requests for hearing were filed, and I thought the resolutions were lacking in terms of 203 because of 203E. They didn't cite, the city didn't cite to a specific, violation of a local land use plan, of zoning, anything. The resolution simply says we are withdrawing our approval. And it's plain as the nose on my face, what they did. They withdrew their approval for the expansion. No ifs, ands, or buts about it. The question is, in terms of 203, did they follow 203 and is it even applicable? That's the question I have.
Yes, if the 2018 resolution can suffice for geographic site approval, the 2022 resolution passed in the same manner
Okay,
can also be a denial under E. I mean, that is the case law provided the hearing officer.
where in the resolution does it reference whatsoever a land use plan or zoning or anything that this expansion would conflict with that particular land use plan or zoning?
I mean, the same requirements apply to the initial approval, and we have withdrawn that initial approval. It
Well,
no longer exists.
yeah, but that's apples and oranges too. Nobody was looking at it under the microscope of a request for hearing and the legality. I think there was an assumption on a bunch of parts, whether it was correct or not, that approval under 203 and maybe approval under 204 was required by the city. But again, I'm just looking at the bare bones aspect of the rule of 203 now, not 204. We haven't gotten there yet. And it doesn't seem that they complied with the city it doesn't seem the city complied with what 203 requires in the intent of what 203 is, which is you enact your land use plan, you enact your zoning, you enact whatever broad brush, plan for development of your location is, and it includes certain restrictions. Maybe this is restricted to commercial, this is restricted to residential, this is restricted to high density, whatever the label is. I think looking at the rule, the city's required to say this expansion conflicts with this facet of somebody's plan. And they didn't do that.
I mean, the resolution is the law of the city of Town. I mean, that is when they pass it and they adopt it, that's it. I mean, but my biggest problem at this moment is I feel like this whole line of reasoning, we've been using words today like evolution of understanding and thought process continuing to evolve. This is post hoc rationalization. That is what we are doing right now to get around the 2022 resolution passed by the city of Town. There is nowhere in the record that ADEQ has made the argument before the permitting decision was made that we are hearing today. What did they base the permitting decision on? That's what I have to appeal. I can't predict what they're going to spring on us later. It has to be stated in the record, and it's not there. And so I appealed what we had there because that's what I thought the decision was, or that is what the decision was made on. And now every step we take, we get a new argument as to how 22.3 either doesn't apply or the city didn't conform with it. That is not how an administrative proceeding is supposed to work. We have to work and operate under the record that we are given. And this is all new. This is all new.
This is the record, Mr. Nolan. Once you file the request for hearing, the permitting decision at that point is no longer final. The record is open. You have the burden, not DEQ, to prove the allegations that you've made in your request for hearing. Don't you? It's not DEQ's burden to prove anything. They don't have to prove a thing. You have to prove it.
They have to articulate the basis of their decision in the decision documents. And there is no articulation of this decision.
Did anybody, okay, well, let me ask you this. Did anybody comment that somehow 203 was being violated by finalizing this permit decision?
I believe Mayor Russell's comment specifically references 203, but I would like to go look at that before I say so for sure.
Sure. We don't have to, you can do it when you're done. Yeah. It may very well be, again, I don't have a photographic memory, and I've read a lot of comments, and a lot of stuff.
This is a moving target. And it's moving before me at this hearing right now. I couldn't have prepared for what you raised a minute ago because I've never seen it in briefing. I've never seen ADEQ say it. Like we have to know what the issue is.
That's a fair point, Mr. Nolan. So if you want an opportunity to brief whether or not what I've talked about in terms of E and 203 and my analysis of what I think 203 means, I'm happy to give you the opportunity.
Okay,
We can do that. And that's a fair point. I granted, DEQ didn't raise it, Ecovista didn't raise it in their motion. I'm the one that looked at it, and frankly, I didn't understand why nobody did raise it, because to me, it appeared to be plain in the language of the rule that you can withdraw support under 203, but you've got to bootstrap that withdrawal of support to some specific land use plan, county plan, district, whatever. That's how I read it. It's contingent upon that, not just a blanket prophylactic. Here we go. You can just withdraw your denial because I don't like it anymore, or for a variety of different reasons. There's got to be an express under 203 zoning plan, something. Okay, sorry.
Your Honor, I had other things to say, but I think we've narrowed our issue down.
203?
Yeah,
Or
in regards
204?
to 203, I mean,
Okay.
so if we are going to further brief it, then I will take you up on that, and instead of going through what maybe you're past at this point, I will focus on
Okay.
future briefing.
I think that's a plan. Mr. Heister?
I want to make sure it's clear on the record that Ecovista understood the inquiries about 22203E to be largely hypothetical, because the petitioners did not raise or cite 22203E in their petitions for appeal. They're obligated to raise those issues of specificity, and they seem as surprised as anyone that it might have some application here. So for them to argue now that, hey, wait, we had a claim under 22.203E is far too late in the game, Your Honor. I mean, I think it's fair for you to consider that as part of the overall scheme, but I think to allow the plaintiffs to claim they could have somehow, that there was that DEQ violated 22.203E. Yet now that the court has called their attention to that in the middle of a summary judgment hearing, I think that would be improper and highly prejudicial, Your Honor. Would object to it.
Hence my questions, Mr. Heister. When I was reading and looking at all this stuff, I said I had questions. And let's face it, 203's, most of the stuff has been briefed pretty well with responses, replies, the whole bit. So, I mean, I don't think any of this maybe should, at least the applicability or lack thereof of 203 to this proceeding is not coming as a surprise. I understand my perspective may be a surprise to all the parties in the room. And frankly, I may be flat out wrong. I'm just looking at the rule, the plain language in the rule, and it seems to me that all those sections are intertwined. They require a plan to be in place, and they require a local government's approval or denial. I guess a denial would be the appropriate way to be somehow there's a nexus between that denial and that plan. That's how I read it. Now, again, I could be flat out wrong. I may be been wrong before. I'll be wrong again.
I don't like to think so, Your Honor, but I know we're to err is human. But I don't think the court needs to actually reach that issue in this proceeding, because I don't believe it was properly raised below.
Well, maybe you're right, Mr. Astor. You could be. So, Mr. Mays, anything you want to pitch in on this?
Written a brief passage in one of my briefs. I believe lost track of which one it is, but addressing this issue. But I think that it's at this point, I think we have probably talked about all that we can here. I think you're right that we need to brief the issue. I certainly endorse that recommend or that decision.
And when I say brief the issue, I'm not opening up the entire process. It's just going to be on 203.
Well, this is a rather obscure issue, I must say, and especially in this and 204 too.
Well, you can put it this way: you can brief all you want, but if it has anything other than 203, I'm not gonna read it. All right, so we've been going for another year. I apologize, I don't mean cut anybody else off on this issue. I think we're down to the last issue, which is 204. Why don't we take a 10-minute break? Because I think this is the big enchilada in the whole thing, as far as I'm concerned. But we'll go ahead and go off the record, take 10 minutes, and we'll be back on the record at 10 of 12. We are off the record.
Next week, go ahead and get started. Yeah, it looks like looks like you got I'm either way. But we said it on the again.
I didn't realize it was when you said. I didn't recognize
Three faces. Second. Right? But second thing. So. More details. Fairly easy. Just set a schedule. Year health information. Right, we need to start with again. We change. Right. Yeah. I see the response that I. Cool. Oh.
All right, councilors, you ready? Before I forget, Michelle and Mr. Mays, the 203 issue in terms of providing an additional brief over the objection of Mr. Heister. Let's see, today's the 15th. Would it be possible to get those that pleading in by next Wednesday, the 23rd? Actually, I would really like it if you could get it in the 22nd. It will give me an opportunity to read it on the 23rd. And for those of you that aren't aware, I'm having back surgery on the 24th. So I would really like to be able to read that before my procedure. Is that doable, Mr. Mays? Mr. Miller, can you have it by the 22nd instead? That'll give me the 23rd to read it. As quick as you can, Mr. Heister. I mean, let's go on a reply basis. How about 5 days? I don't want to string this out any longer than I'd really like to have an order. And I think, assuming that the next issue, let me preface all this. I think everything that we've discussed here this morning so far, I really don't believe there are any facts in dispute. I really think we're all on the same page. Maybe not with 203, it's possible. I'll take 203 out of the equation, but everything prior to that, I think there really aren't any facts in dispute. And I really do believe that they can all be decided as a matter of law. I'll hold judgment on the 203. I don't think there are any facts in dispute on that either. I think it's a pure legal analysis, and I'm either right or I'm wrong. And I will wait to see what Mr. Mays and Mr. Nolan have to say, and you folks as well, about that. All right, 204. I think this is the last issue. I think we covered everything in everybody's motions. And if we haven't, please let me know. Who wants to go first? How about DEQ? I'll make the decision. 204, Schrebenet.
I think this is where we were trying to start last time, Your Honor. We're looking at the issue of whether or not alternatives analysis was required, and then somehow that devolved into 22-203. So I'm ready for your questions on 22-204.
Well, I guess the biggest question is, I gather based on your analysis that host community approval is no longer necessary or required under 204, correct?
That is correct, for a myriad of possible reasons.
Yeah, so But apparently that wasn't the position of the division, at least when pre-application came in. Is that correct?
For pre-application, I believe all we were required is to have some indicia of host community approval. And the 2018 resolution did have that. It was looked at and the application proceeded. The issue was never raised again.
Right.
So, but I mean, we're in uncharted territory, Your Honor. I mean, really, the General Assembly doesn't tell us what we're supposed to do. If some sort of statute or some sort of ordinance is passed that revokes approval or anything like that. So we're way out there and we're trying our best to figure it out.
So flesh out a little bit for me why the division no longer believes host community approval or 204 is necessary. Is there something in 204 specifically that you are hanging your hat on? Now, keep in mind, I've read the motion for summary judgment, and I think I understand it.
Yes,
But maybe if you could just elucidate a bit more,
yes.
what led the division to the conclusion that 204 was not applicable to this permitting decision?
Well, let me couch that just
Sure.
momentarily. And if I can try to couch this in a manner that does not further muddy the waters, confuse the issue. Host community approval is a discrete requirement from geographic location 203.
Correct.
Host community approval means we know that this facility is here, we accept it. We can accept it if we're the host community expressly by an ordinance, or we could accept it perhaps impliedly by accepting certain benefits. Or we could have a hybrid approach where we have maybe solutions and ordinances approving and acknowledging of the benefits. If neither of those are on the table, then we get to kind of a brute force problem where our applicant is going to have to prove that there is no other suitable geographic site for this facility. So if it is shown there's express acceptance, we don't have to look at incentives. We don't have to look at alternative sites. If that express approval is missing, then we have to look at those two issues, and we can look at either or. We don't have to look at both. The statute is conjunctive. You must either show there is no other suitable location for that facility based upon geologic factors, or that the host community has accepted the facility by accepting the incentives. So that, when we talk about applicability, okay, I think what we're trying to nibble at here is that it could either be already in compliance, or perhaps it is not wholly applicable. Either one could be true in this case. To flesh out why it could be inapplicable, we could look at the statute and see that the statute says that this only applies to new high impact solid waste management facilities. Is this a new facility?
And that's what 204A says. Says it's a rebuttable presumption against permitting the construction or operation of a new landfill within 12 miles of an existing high impact solid waste facility, which that's not what we have here. We have the expansion of an existing landfill.
If I
site.
can, right,
But I mean, and the rule is just, it's frustrating. Because if you read A, it seems like it applies to a new landfill. But then if you look at the very last line of C, it says the division shall not process any application for a new or increased landfill acreage or an application for increased landfill capacity until definitive findings in conformance with this section have been provided by the host community and accepted by the division. Acceptance or denial of a landfill siting by the host community shall be by formal resolution of the governing body of the host community. So if I look at A in isolation, it's new. If I look at C, it's expansion. And new is what's the division's position in regards to that? They seem to be polar opposites, or at least an extension of what A is. But it's in the rule.
Yeah, and I don't know how the rule really tracks with the statute, because the statute doesn't say that. Statute says what is exempt. 15.86.15.02. The exemption applies to, let's see, I can find it. 3B does not include, so 18.6.15.02, 3B, little letter, Roman numeral 4, solid waste landfills which have applications pending for either increased or new acreage or provisions for additional services or increased capacity. So, yeah, the rule already seems to be kind of struggling against its statutory authority.
Well, you say that, but C doesn't expressly conflict with statutory authority. And of course, the statutes are always enabling. The rules are interstitial. They fill in the gaps. And it is what it is. I mean, C is there. It seems to indicate that it expands to new as well as expansion, as well as increased acreage. So you're not suggesting that I ignore C, are you, Mr. Robinette?
Well, let's, what about, we have B24, which mirrors the statute, but for some reason, the commission has inserted a date within the exception. Landfills which had pre-applications or applications pending for either increased capacity or new acreage as of August 13th, 1993. Judge, that's 90 days after sine die in the 1993 session. So it seems that our rule makers looked at the statute and decided that they would not make it prospective, but instead place a cutoff date at sine die. So I'm not sure how that jives with the statute. Have we properly implemented that or not?
Well, I've been doing this a bit now. And I don't think I've had the cojones to say, Commissioner, your rules are in violation of the law. I mean, isn't there a presumption that, just like under statute, that unless you have something expressed that clearly conflicts with the statute, it's considered to be valid and legal? And this, I mean, C doesn't conflict. I mean, granted it expands what's in the statute, but it doesn't conflict with it.
Okay.
Right?
To your point, certainly we could read it that way, Your Honor, that C may expand the statute rather than conflict with it. So assuming that is the case, then I believe the analysis goes on to, does post-community approval expressly exist, or is host community approval provable by the acceptance of incentives?
Well, certainly there are a number of agreements that are part of the record where there's been some vestige of quid pro quo consistent with 204 between the city and Echo Vista. I mean, I can't remember off the top of my head all of them and all the iterations of the agreements, but I think the last one was, the city agrees to support Echo Vista and grant approval if Echo Vista pays $100,000 a year for 3 or 4 years and plants some foliage and puts a new fence to try to curtail blow litter from the landfill itself. I mean, there are a number of things. I mean, frankly, I look at the host agreement, you can label it whatever you want. But it's a contract. It's a contract between the city and Ecovista, right? And so why isn't this just a plain vanilla breach of contract dispute? The city's withdrawn their support and they are in breach of the agreement. Why does the agency even have to get involved?
Again, I think this goes back to the fact that we're in uncharted territory. We don't know what happens if a host community subsequently withdraws their approval. We know at the time of the pre-application, we had approval and we processed the application, and it's only until the 11th hour that suddenly it appears that perhaps this approval has disappeared. But I'm not so sure it disappeared. And going back to breach of contract, certainly, you know, there is always circuit court as a backup remedy, but that doesn't have anything to do with the agency. The agency
I agree with.
has to issue its permits.
I don't dispute that at all, but let's play law school a little bit. So the city's agreed to do certain things, the Ecovista's agreed to do certain things. Let's just say for the sake of argument that Ecovista reneged on what it agreed to do for the city. Wouldn't the city at that point have the ability to withdraw support again because of a breach of an agreement? Regardless of when it took place, pre-application, right on the eve of the permitting decision being made by the agency, it's between Ecovista and the city. Granted, I mean, we don't have any particular control over it, but it's their agreement, it's their contract. I think at one point there was an argument that there wasn't a rule or anything on the book, statute or rule that allowed the city to withdraw support from this agreement. There's nothing that on the rules of the statute that says they can. Same thing with Ecovista, I would think. I mean, that's between Ecovista and the city. Now the city may be opening up itself up to a variety of different litigation by reneging on the agreement at the 11th hour. That's between the city, Ecovista, and their lawyers. But at the end of the day, isn't that what we've got? And because we have this breach, let's assume for the sake of argument, host community approval is required under the rule. Can the division make, or can the commission even make a decision until that breach issue has been resolved between the parties?
Well, Judge Moulton, the exact language is it says that we shall not process any pre-application or an application until definitive findings in conformance with this section have been provided by the host community, accepted by the division. So first of all, at the time of the pre-application, we certainly had it. At the time of the application, we certainly had it. We're now talking about months post the application when we've received this ordinance that maybe withdraws support. Not real sure if it withdraws support.
That dovetails back to my earlier question on 203, which is the division is always receptive to new information, new arguments, whatever, up until the point where you make your final permitting decision, correct?
We're receptive to it,
Yeah.
but what is our obligation to act upon it is the question.
Well, I guess that's the quintessential question, right? But if you, but again, let's just, if the shoe's on the other foot and it was Ecovista that reneged on their agreements. Let's just say, again, this is law school rhetorical. Wouldn't the city have every right to say, well, you're not upholding your end of the bargain. We're pulling out of this and we're withdrawing our support. What would the division do? Would you just process the permit because it's so far down the road at that point? Is that the rationale?
Indeed, a very hard question, which requires a lot of speculation. And certainly I'm not the director or the secretary. So it'd be very hard for me to articulate that policy.
I'm the only one that's allowed to play law school. Not you. and I'm not trying to be facetious. I am serious because I'm looking at it from the perspective of, again, there's been an argument that the city was powerless to withdraw its support. Once it gave it, it couldn't take it back. And frankly, I think with any kind of an agreement between two between two parties, if one reneges, there's a breach. That's how I look at it. Again, I may be completely off base, and the city may be opening themselves up to a bunch of litigation. I'm surprised, frankly, that has not occurred yet. Maybe Mr. Heister can fill me in on that point. There's always the remedy of specific performance. I mean, there's a variety of different things. But for whatever reason, these resolutions, this agreement, the city backed out of it. And of course, I know why they backed out of it. They've got a bunch of folks in their community that are complaining about the operation. Maybe the city's argument is Echo Vista breached because they're not operating that facility the way they think it ought to be operated.
So at what point would this breach take place in the permitting or the application process? That's
Well, when
to
you
answer
get
your question.
when you get the resolutions, I would probably say that's the breach, and it's before you made the final permitting decision.
Before, after the application,
After the application,
After
after the pre-application, the whole bit.
we are now well within the permitting process.
Right. You are.
Unfortunately, the General Assembly has not seen fit to tell us what to do. So at that point, it seems like the right thing to do is to follow through with the permitting process. And if there is some sort of independent remedy, because I want to go, and this is very sticky because it's not like the zoning issue. The zoning issue, they have a legal process and their own jurisdiction in place. So, it just seems from the writing of this rule that our jurisdiction over this process seems to end at the time of the application. And then after that, it seems like all bets are off. And
Other facts in dispute on this issue, Mr. Revenant.
so I think we're back to an issue of law. And the issue of law that I see here is, did those resolutions revoke host community approval? And we can look to the four corners of those resolutions. They seem to express a displeasure at the fact that the permit is moving forward. They don't say we revoke our host community approval pursuant to Arkansas Pollution and Control Ecology Commission Rule 22204 and Arkansas Code Annotated 86-1501 et sec. They don't say that.
No, I don't think the rule requires them to say that. Unlike what I think the rule in 203 requires them to say. It just says, let's see here. Acceptance or denial of landfill siting by the host community shall be by formal resolution of the governing body of the host community. So I'm looking at the prongs. Certainly, the city meets the definition of host community. Certainly, the city council is the governing body of Town. And then certainly we have two formal resolutions withdrawing support. I mean, it's pretty plain to me that they're no longer in favor of the expansion of the class 4 zone. I mean, it's not at this point, it's not rocket science, it's not engineering, it's not science at all. They're not in favor of it. They want it denied.
Well, if the feeling is that the resolutions are on their face and within their four corners sufficient to revoke host community approval, then I think we have to go to the final step. I mean, is
it necessary?
Well, I think, is it now implied? Can you say one thing and do another thing, Your Honor? And then take the benefits. Can you accept the milk and not buy the cow?
But the agency doesn't have really a role in that. That's between
Well,
the city and Eco Vista.
I maintain that our role stopped when the application was submitted because the approval was unequivocally in place. And now, we're off into the mystic here. And so what is the agency supposed to do? That's
How much time elapsed between when the application came in and the final permitting decision was made?
okay. The application, I believe, came in July of 21.
I believe that's
Yeah.
correct.
July of 21 was the full application.
And when was
Well,
the first resolution? And granted, the first resolution kind of vacillated a little bit. It was like, it was something like delay this or deny it, or it's to that effect. The second one was, we're not in favor of it, deny it. So I could see that, perhaps the agency with the first one might have been like, what do you want us to do? The second one was pretty plain to me that they wanted you to deny that they were withdrawing host community support. The second one came in, I believe, in January or February of this year, if I'm not mistaken. So a number of months before the final permitting decision was made.
It was January 23
Yeah.
of 23. So it was approximately between 6 and 8 weeks before the permit issued.
Yeah.
Um,
I mean, plenty of time for the agency to look at this, digest it, and try to determine what the legal ramifications were, correct? Or maybe not, I don't know.
so fine. Something. I'm trying to find what we said about the language of the resolutions. Digging pretty deep here.
Well, maybe I can help you with the time frame, Mr. Robinette. So November 2nd was the public hearing of 2022. And at that public hearing, Mayor Russell got up and I gather pretty plainly said, city is withdrawing its support. So at that point, the division was on notice that the city was withdrawing support because that's the response to her comment on page 57 of 125. DEQ acknowledges the subsequent city resolution withdrawing support.
So I would say this, certainly it sounds like you've firmly come to the conclusion that the January resolution withdrew host community support. That's what it sounds like to me.
Well, that's what it says, Mr. Chairman. I mean, and again, I'm looking at DEQ's response to the mayor's comment. I could be flat out off on that, but
Again, I do not possess an eidetic memory either, Judge.
I know there's a lot of paper and a lot of information flying around.
We will table that, put a pin in it for a moment
Sure.
while Ms. Thompson
Okay.
uses, she can dig it up, but let me go to, let's just assume for a moment that that resolution was sufficient to withdraw host community support. I think now we have to look at the statute. Okay, the statute says in section 1504 that there's a rebuttable presumption against one of these high impact solid waste management facilities. That's section A1. Section B, the presumption can be rebutted if any of the following is shown. So number one is our citing. Our citing is there's nowhere else to go. Okay, but number two, remember, if this can be rebutted if any of the following is shown, that incentives have prompted the host community to accept the siting of the high impact solid waste management facility. Such incentives may include, without limitation, increased employment opportunities, reasonable host fees not to exceed the prevailing state average, contributions by the high impact solid waste management facility to the community infrastructure such as road maintenance, park development, and litter control. Compensation to adjacent individual landowners for any assessed decrease in property values, or remember, these are all disjunctive, or subsidization of community services. So certainly if we no longer have the express approval of the host community, we could still issue a lawful permit if it is rebutted, if the presumption is rebutted by the showing of these factors. Clearly, the record shows that Town continues to accept the benefits. And in nowhere in this resolution are they saying that they're disavowing themselves of these benefits. They like the benefits. They like the checks. They like all these things that are flowing to them. And so how can you say one thing and do another? And I think, and I'm a firm believer.
Those might be facts in dispute, Mr. Robert.
Are they in dispute, Your Honor?
I don't know.
Because I think we've seen very clearly that host community agreement is in place, has not been modified or revoked.
Well, they may like the money,
The
but
money
I don't
has
think they
been-
like the landfill.
Some of the money's been spent, Your Honor,
Okay.
you know? So
Well, that's why they're in breach, right?
we get it, again, I'm not here to litigate a contract dispute. I'm here to support a permit.
I understand.
Division entered. So I'm looking at, now that I have this ordinance or resolution, it's very easy to get the two confused. Let's read it. Do you have it in front of you, Your Honor?
I do.
Okay, so let's go past the findings and look at the now therefore be it resolved by the City Council of the City of Town, Arkansas. Section 1. It is hereby the express desire of the Town City Council for the reasons set forth above and the extent possible the final approval of the landfill expansion be denied. So they have an express desire that the expansion be denied. Now, what does it say here? And I guess we do have to look at the whereas parts. What does it say here about the lack of host community approval? Okay, continuous problems. It doesn't say anything in here about with denying the acceptance of the benefits. It talks about a lot of reasons why they don't like it. And they would like the permit denied, but it doesn't say, hey, we revoke our host community approval. Now, and Judge Molden, I know you've said it, you don't seem to think that he needs to say those words, but four corners of the instrument here, I just don't see where you get to the revocation of that approval. I see that they don't like the landfill and they would like the permitting to be denied for reasons that involve operation and so forth, but not that it's not providing them incentives.
Again, I don't disagree with any of that, Mr. Robin. I agree with that.
So
I agree.
So I feel like this was just not strong enough to constitute a breach until, we actually stop accepting benefits, until the city, shows up with some padlocks and chains and change the gates of the facility. I don't know. I just don't feel like
that might be a stretch a little bit too far. I don't think they've
I
got
had
the
many
authority to
years
do that.
I had many years in oil and gas, and that happens, Well,
here's, I guess to me, where the rubber hits the road, you've made the argument that 204 is not applicable. Host community approval was not necessary right out of the gate. It's belt and suspenders, it's redundant because 204 doesn't apply, right?
Now, well, okay.
I mean, you've made arguments on the alternative that if it does apply, even, it doesn't apply, but if it does, they haven't properly, they being the city has not properly done a resolution or hasn't properly withdrawn host community approval the way the rule anticipates it should be done.
I feel that is accurate.
Okay. Okay. How about if I hear from Mr. Heister?
I think that is an excellent idea.
Yes, sir.
Thank you, Judge Moulton. Again, a lot of territory to cover there, but I'll try to keep it simple because at its heart, I think it is. The rule creates a rebuttable presumption. Rebuttable presumptions are common in the law. It's a threshold showing. And here, there doesn't seem to be any dispute that the rebuttable presumption is met and DEQ was proper to carry on. And that's all the rule requires. And as a general matter, that really is the end of the analysis. It's not any more complicated than that. Now, I think the DEQ is correct insofar as statute and the rule itself shouldn't apply here by the plain language of the statute. And there we go back to, I guess, page 6/1501. The General Assembly was very clear what its concern was with the statute, and it wasn't giving municipalities a veto over landfills. The concern was certain low-income communities who have historically been unduly burdened by the oversighting of these high-impact solid waste facilities. Making sure that if they are going to have those facilities in their area, that they receive some sort of compensation that's acceptable to their local community leaders. That was the point of the statute. And I respectfully, at one point it was suggested that the General Assembly gave some authority to the agency, and the agency can kind of riff off that and expand upon it. I mean, I think there are cases like the Hempstead County decision, which was not regarding DEQ, that was an APSC decision, but I think the DEQ, the APSC, these other state entities are creatures of statute, and I respectfully disagree that they have the power to go beyond their statutory authority. Now, if it's a general enabling statute, that's one thing, but where you have a very specific statute that lays forth certain authorities to the agency, I strongly disagree that the agency has the power to go beyond what the General Assembly saw fit to give them. So when the General Assembly says, look, this applies if you've got a facility within 12 miles of another, the agency can't change that. They can't rule make their way around it. And to the extent they try to, that's invalid.
So are you arguing, Mr. Heister, that you think 204.3, I'm sorry, 204, yeah, 204.3C. No, that's wrong. I apologize. 204C is that particular section of the rule is an ultra-virus rule.
As it's being proposed to be applied here, yes.
Okay. But aren't I obligated to follow the rule regardless?
Well, that gets back to the law school question. Say, okay, well, when we have a rule that seems to be statute, is there a manner that we can read it somehow to iron out the kinks? And we made a point of calling to Your Honor's attention the fact that 204A, a couple decades ago, had language in it expressly applying to existing facilities. You're right,
Mr. Husser. If we were just relying on 204A, this would be an easy done deal because you wouldn't have even entered into a host agreement with the city of Thompson, right? Your client wouldn't have done that. I mean, they looked at C, thought it was applicable as well, and entered into these agreements. Or did they?
I respectfully disagree with you, Your Honor, simply because there's no evidence in the record about how many of these facilities are within 12 miles. So it can very much be the case, obviously facilities closed, as your honor's aware. So it can very much be the case that there were 2 facilities in existence at the time, and there aren't now. And again, that's my point. They made no showing as the plaintiffs with the burden here of showing 204's application. They have not given you evidence of the 2 facilities within 12 miles of Town. So what record there under which the commission could kind of rule in their favor that this statute applies? They haven't met the threshold showing.
Is Town in breach of the agreement that they had with Echo Vista in terms of what I'll just call it the host community agreement, in your opinion?
Certainly in the spirit, your honor, I'm not prepared today to go any further than that.
Okay.
But I think Mr. Robinette was correct in intuiting that the existence of a breach of contract action here or not really isn't relevant to the outcome on this issue. That one, Rule 22-204 shouldn't apply. It's in our briefing. I won't go back over that. But even if it does, all it does is create a rebuttable presumption. It does not create, and this is where I think the law school logic takes you, it does not create a veto over the agency's authority. That is a very strong grant of power that is found nowhere in the express language of the statute. And if that is in fact what had been intended when they enacted 1501, then that would have been made expressly clear. What the commission can't do is kind of infer it. So you have to read 204C in a manner that doesn't run afoul of that.
Well, I don't know about that, Mr. Lester. I respectfully disagree with you. Take C out of the equation. All right. We still have A. Let's just say this was a brand new facility and all the parameters of A were met. Then it's incumbent upon your client to make certain that the host community where this new landfill is going to be sited is given sufficient incentives to allow it to happen, because a landfill can have a fairly big impact, both positive and negative, on a community. And so I think the General Assembly was cognizant of that. And rather than have these landfills sited in spots in the state that are impoverished and don't have the ability to, lawyer up and fight for themselves, they enacted this to make certain that these types of facilities weren't located in spots like that, to give those host communities some vestige of ability and control over the process. Now I'm taking C out of it. I'm looking just at A. That was the intent, wasn't it?
Yes, I think that's
Yeah,
right.
I think that's right. Okay. And now granted, now we have the bugaboo of C and what it all means, whether it's legal or not, but it's certainly there.
Well, but you can't ignore the language in A either.
Right.
Which and what kind of whatever that approval, all it does is, the breadth of C has to be read, in terms of the applicability and scope of A, and that's how that section is titled, applicability and scope. So if we're going to give C some meaning, then it has to be consistent with A, where again, all that's being done here is the creation of a rebuttable presumption. And again, it's noted in our briefs, the 2018 agreement with the city, the memorandum of understanding, there were all sorts of benefits conferred upon the community. The city accepted. And I reject the characterization of, well, the community doesn't want it. The community has been fine with it for decades. There was an election. There will be elections in the future. So I don't think it's fair to say, well, obviously the elected leaders speak for the people that day, but did that mean the elected leaders in 2018 were illegitimate? We sought discovery on this and asked, was anything you did in prior city unlawful? And it was lawful. There's no dispute about that. So all those actions were perfectly lawful. And so the question for you really should be, DEQ seeing that, was it enough for them to say, okay, the presumption's been overcome, it's been rebutted, and we can proceed with the application of the permit? And that's all that expressly speaks to. Everything else is kind of, we're gap filling in a manner that isn't consistent with what the statute intended.
Well, we're getting a little bit outside the reach of a motion for summary judgment and what's been pled in the motion for summary judgment. But I grant you, Mr. Heister, obviously something changed. At one point, the city embraced this facility, this landfill. Apparently, everybody get along. And now that's not the case. And frankly, we had an individual, a mayor, who, from my understanding, ran on one issue and one issue only. And it was your client's facility. And that was sufficient to get her elected. So that indicates to me that there are issues with your client. Now, granted, I think they are outside the four corners of this permitting decision. They may be enforcement related. They may be community outreach related. I'm not smart enough to give you an answer on that, but certainly something has changed. Something has changed.
Well, as we took her deposition, and Vista didn't offer to buy her property at a high enough price, so she ran for office. So that changed.
Yeah.
She's a next door neighbor to the landfill, has been for decades.
Right.
Not exactly a new neighbor. So, I mean, Your Honor, I think all of that is outside the record. None of
it absolutely
my
is.
My testimony here is none of that is really what is proper here.
And as a practical matter, I am going to have to, when push comes to shove, again, the city has been, and some of the residents of the city have been attending commission meetings now for almost 2 years, maybe even longer, I'm not certain. And they have shown pictures of a variety of what they described are ills or compliance issues or whatever. I'm going to have to make certain that the commission is cognizant that those things really don't have, they need to set that aside and just make their decision on the record, but it's there. I mean, it is an undeniable fact that it is there. So you need to be aware of that. Your client needs to be aware of that. And again, it's just something that's the reality of what we're dealing with. So we're off on a tangent, and I apologize. Let's just go back to 204.
Yes, Your Honor. I wanted to call your attention back to it's Exhibit L in our motion, but it's the second of the two Tontitown resolutions. Can
you hold on a second, Mr. Let me grab it.
I said it's Exhibit M to our motion. Yes, sir.
Got it. So I'm sorry, you're looking at the resolution.
Yes, Your Honor.
Okay.
And the section 1 here reads, it is hereby the express desire of the Tontitown City Council for the reasons set forth above, and to the extent possible, that the final approval of the landfill expansion be denied. So, first of all, I think that the city's disapproval was always qualified with, to the extent this can legally be done. Obviously, our position is that it could be legally done. And the failure of the city to enact any change in the EU zoning ordinance that lawfully allows us to operate, the failure for them to take any action in respect to the large-scale development plan that they approved for us. Obviously, they continue to accept tipping fees, but the city expressly approved the lawful operation of the current landfill throughout 2018, 19, and 20 under measures that everyone agrees are lawful, and were all enacted by the city council. And so the argument that a kind of a 3-sentence ordinance that doesn't reference any of that can deprive my client of an otherwise lawfully issued permit, it pushes the rules far too far. And it's a clear violation, I think, of both my client's substantive and procedural due process rights. Because again, there's nothing in the rule that suggests such a extraordinary branch of authority being taken away from the DEQ. Because according to the rule, all that it creates is rebuttable presumption. And so I think it would be error for the commission to give the city's actions any more power than that, especially when they independently have no legal effect whatsoever. I mean, the city wants, as you know, they kind of want to have their cake and eat it too. They want to protest this thing or oppose it, but they've taken no actual, apart from this permit challenge, which, is not resolved yet. They have actually done nothing that, well, and I'll leave some other minor ordinance enforcement actions to the side here. Kind of with respect to the class 4 permit, they've taken no action of legal consequence here. And so, that's why I think our arguments, our motion for summary judgment should be granted. And unless you have any questions for me, I'll let my
I think I'm almost questioned out here, Mr. Heister. It's already been a long hearing process.
we all
Let's
appreciate
hear-
your patience.
Thank you. All right, gentlemen, who's gonna talk first? Or are you both gonna talk? Go ahead, Mr. Mays. And I will tell everybody that we've got, I hate to give you a time limit now, but I've got another 35 minutes, so about 20 past 1. I've got another command performance with the Oil and Gas Commission at 2. And I apologize, I thought we'd be done well before this. Go ahead, Mr. Mays.
Thank you, Your Honor. Your Honor, I'm going to focus on what the rule says rather than the history of it or what the statutes say or any theoretical or other aspect of this. That's what we have to deal with.
I know what it says, Mr. Mays. I mean, I've read it more times than I care to count at this point.
I did that too, but it's not that complicated if you get right down to it. Subsection A of 204 sets up a rebuttable presumption against permitting any new landfill within 12 miles of an existing high impact solid waste facility. There are certain circumstances where that presumption can be overcome, and I'll come back to that in a minute. Section B defines what a high impact solid waste management facility is, and it includes any open solid waste landfill, which would cover this landfill in question. And then subsection C says the division shall not process any pre-application for a new or increased landfill acreage or an application for increased landfill capacity until definitive findings in conformance with this section have been provided, and that acceptance or denial of a landfill siting by the host community shall be by formal resolution of the governing body. Now, this clearly applies to this case, seems to me. You can the presumption that for overcoming the overcoming of the presumption can be done by showing any of these 2 and then subsets of 2 conditions, which I'm not sure have been shown. Is there a suitable alternative for this site? Does the record show that the applicant, Vista, has shown that there is no suitable substitute for alternative for this facility? It's their burden to show that. It's their burden to come forward with to rebut the existing rebuttable presumption.
Well, didn't they do that with the host agreement, Mr. Mays?
I'm not so sure that would be evidence that there is no other site available or could be available.
Well,
There's
I mean,
lots-
they entered into a host agreement.
The
It seems to me the way the statute reads, there's a rebuttable presumption.
Oh, okay.
Yeah, but I mean, once they enter into that host agreement and the host community accepts the siting,
You're talking about,
they've overcome that presumption.
you're talking about the incentives.
Correct.
Okay. That section 2 says incentives have prompted the host community to accept the siting.
And they did at one point.
Well, they accepted it before these incentives were given. And it doesn't, the question is whether the incentives that are in these various agreements that are involved between the landfill and the city have prompted the community to accept it. That's the question, whether it prompted them, because the landfill was located there before any of these incentives were, and if you want to call them that, they're basically, I mean, Echo Vista has a monopoly there. They don't have to give incentives. They give them because they want to try to maintain a good relationship with the community and to keep down opposition to the landfill.
Mr. Mayor, I think they gave them because 204C says every single time they expanded or whatever, they, rather than risk having the city deny that the application for expansion, they entered into these agreements. And it was a quid pro quo between the city and Echo Vista.
Well, the rule says incentives have prompted the community to accept the siting of the facility. I'm not so sure that that has been shown either. They have given the incentives. I'm sure it was all very welcome and glad, and that the community was happy to receive them. But whether that has prompted the host community to accept the siting of the facility is a different issue. But even more important is whether those incentives are a commitment on the part, involve a commitment on the part of the city to never challenge a renewal of a permit application, a renewal of a permit. There's nothing that I've seen in those agreements, and I've read through them. I can't quote them verse and chapter, but I have not seen anything in those agreements where the city waives any right to challenge a renewal application of one of those permits. That's what we're doing here.
They can challenge it, but their challenge is predicated on them essentially withdrawing their support that they agreed to in the most recent iteration of a host community agreement.
Well, those agreements have to be entered into with the understanding that the Echo Vista has a permit to operate that expires within a certain period of time. And that if they do apply for a renewal of the permit, it's the right and opportunity of every citizen, and including the city, to challenge that permit renewal. There is nothing in those agreements that says that the city cannot do that the city has to roll over and play dead and let the landfill renew their permits, regardless of how they've operated the landfill. The city is exercising a right that they have. It's not given up in those agreements. And you were talking about the city breaching the contract. I don't see that in those agreements. The city still, there's nothing in there that says the city cannot oppose a renewal application. And that's what they're doing here.
Have you read the host community agreement? It basically says Echo Vista is going to do X, Y, and Z. And in response to X, Y, and Z, Town is going to go ahead and give their blessing to the landfill facility for its life.
Well, I don't recall that being in there, but
I do.
the life, okay, but even if it is, the life of the landfill is determined by the length of the permit.
I understand. And I understand it was a previous administration that agreed to that.
Yeah.
But it's in the record, Mr. Mays.
Well, it may be, but it still doesn't mean that the city cannot challenge a permit because the life of the permit.
Obviously not, they're here. They're challenging the permit.
Right, and the life of the landfill depends on whether the permit is renewed.
Okay.
So given that, and C says the division shall not process any application for an increased landfill capacity until definitive findings in conformance with this section have been provided. Now, the definitive findings, and the word definitive here is a key word, because definitive usually means clear, clarified, trying to resolve any ambiguities. And the resolutions that the city passed in 2022 in November, and then again in January of 23 are very definitive. They recite the problems that exist with the landfill that cannot be resolved by a municipality under Arkansas law, that the problems have been reported to DEQ and others, nothing's being done. So they are terminating or withdrawing their approval for the reciting of the landfill. There's nothing that prevents them from doing that.
I don't disagree with that at all, Mr. Mays. They've withdrawn their approval.
Yes. And that withdrawal, the November 22 resolution was adopted 6 months before the permit was issued. The other one was issued 3 months before. So it's not like this is a last minute, although it was characterized by Vista as being last minute. It wasn't last minute. There were still hearings being held and still decisions being made.
No disagreement from you, Mr. Mays.
I'll quit on that.
Thank you. Mr. Nolan.
And I'm last, and we're out of time, so very quickly, I want to just reiterate my concern with how ADEQ has made its decision regarding 204, similar to what I stated about 203. There is no definitive statement in the record finding how it is applying 204 to this situation. In fact, we confirmed that through discovery, where they stated in response to our interrogatories, they are unsure about the applicability of 204. That is not meeting the standard that ADEQ has to meet to articulate its decisions in the record. Any decision or going one way or the other after that is all a post hoc rationalization of what a goal they are trying to achieve now after having issued the permitting decisions. So that's all.
Mr. Lanigan, I'm back to what I said before, that there's not a bright line in terms of stoppage. If there was, and pre-application was where things ended, these resolutions passed pre-application. Pre-application wouldn't be able to be considered at all. So as far as I'm concerned, the record is still open. We're making a record now. The administrative record is open. Evidence is being considered, arguments are being considered. So I understand your frustration with the evolution of the EQ's argument. I'm a little, frustrated with it too. It didn't even appear that was the argument, or at least that was the position of the division when motions to dismiss were filed. It only occurred with a motion for summary judgment. But again, the administrative record's open. We're still developing it. So I know, I get it. You're friendly. I
It's
understand.
difficult for me to grasp because my understanding is that you have a permitting decision and that is what we have to appeal. Now here we go on all these different paths.
I agree with that too. But
I'm just making my
when you have
recommendation. Sit down.
when you have a request for hearing, I've seen it before. Positions tend to change sometimes. When legal arguments start flying around, the sands start to shift and people take up different positions. It happens in litigation all the time. You may file a complaint and then somewhere down the road, you have to amend it, have it conform to the evidence. I see it as analogous. I understand your concern though, because you're looking at it from the standpoint of here's the permitting decision. From DEQ's perspective, the record is closed. I think that's your argument, right?
Yes, and then I have to know what I can appeal from that based on their decision, and that they have to document those decisions in the permitting record.
And at least when you filed your request for hearing, you were under the impression, as well as everybody else, that 204 and 203 were applicable.
Yes,
Yeah, they're
absolutely.
both applicable. I get it. I get it.
All right, thank you, Your Honor.
So before you sit down, the argument about 204 not being applicable, that DEQ and both Covesta and DEQ have raised, why is that in your mind wrong?
Well, may I back up one step first? And I think I just said it, but it's that they would need to say that in the permitting decision. And they have failed to do that. And everything up until that point indicated that they were making a decision on 204. I put references in my brief from the pre-application and the application that referenced 203 and 204 in those application materials. So again, it's the record that I am looking at, which is my understanding of an administrative proceeding. So it was their decision that it applied. Now, if they had chosen not to apply 204, I would have appealed that. But I'm appealing the application of 204 and saying that there is no record that they did an alternatives analysis. You know, that I have to appeal what is before me, you know, and what the record appeared to be. So I mean, it from the record, it absolutely appeared that 204 applied. And we've said, well, if you're going to apply 204, you're going to have to consider alternatives. And there were no alternatives considered.
But you've read DEQ's motion, and I know that you were not happy whatsoever with the pivot
Yes.
based on your response. So reading what they have pled in their motion for summary judgment, do you disagree with their analysis? Not from the standpoint of a potential sandbagging or things of that, just the pure legal analysis that they've set forth.
I mean, we're talking about 204.
204.
I mean, 203 is a whole nother thing. We've
Yeah, just
been
204
all
for
of
now.
that.
Yeah.
I mean, I'm going straight to 204C and it says permit expansion or modification, which we have.
What about the argument that C is in conflict allegedly with the statute?
That would have been a wonderful thing for them to state in their permitting decision, and then we could have appealed that and litigated it. But I mean, either it applies or it doesn't, and we have a permitting decision that was based on 204 applying. That is the world that we have to operate within.
This is outside the scope of the motion for summary judgment. And I'm giving you that caveat. What does your client want? What does the city want? Do they want this thing completely shut down? Is that what they're aiming for? And do they understand the repercussions to their residents if that happens?
You know, we're bordering on the counsel that I give my client, and I'm not going to respond to that.
Okay.
I
Anything?
mean, I
Yeah.
will respond to what do they want. They want the permit denied. That's why we filed the petition.
I gather they want the landfill shut down. Or you don't know that for a fact one way or the other.
Well, if the permit is is denied, then it would assumably be shut down.
This is just a class 4. There's a class 1 coming down the road here. Now, granted, there may be a lot of overlap with those arguments. But I was aware that potentially their residents' landfill bills could skyrocket, right?
Again, you know, conversations that I have between my client and I'm not going to speak to today.
You know, if I had the ability, but I don't as a commission ALJ, just on this one narrow 204 issue, I'd make you all sit down at a mediation, non-binding mediation table and see if you can't work something out. I get the positions of everybody in this room. The city's tired of the burden of dealing with this landfill, the trucks, the conditions. They probably thought that this thing was going to go away years ago, and it has not. I remember vividly back in the 90s when this was Sunray Services and they tried to put a landfill off the mountain because they had a recognition that this site probably wasn't the most ideal for a landfill. Again, this is completely outside the scope of of the motions for summary judgment, the merits of the request for hearing or whatever. But, you know, I found it interesting that the first resolution that the city passed was a request to delay or deny. And I don't know whether or not everybody sat down around the table in terms of what you could try to achieve amicably. Maybe that hasn't happened. Maybe there's been attempts. I mean, the landfill has to be aware that the city and its residents are an unhappy bunch. And while they're not trying to do more to address that, maybe they have. I don't know. I mean, again, that's not part of the record, but I'm going to have an assumption that it has not happened. The city has to be aware that if this facility would have shut down completely, it would reverberate throughout Northwest Arkansas. Maybe they don't care about that, including the residents. Maybe they do. I don't know. But I don't have that power and I don't have that authority. But it'd be nice if you all could consider it.
I don't mind sharing.
You don't even need to
My
respond.
clients to
That is,
listen.
that is pure, unadulterated, probably improper assessment and speech on my part. But given everything that's at stake, no, if I make a decision, there are going to be unhappy people one way or the other. I would love to be able to avoid that. In any event, anything else to add on the 204 motion for summary judgment issue, Mr. Nolan?
No, Your Honor.
Anything from DEQ?
No, stand on our previous statements and others.
Sounds good to me, Mr. President. Mr. Meggs?
No, Your Honor.
Mr. Heist?
One quick point. In our filings, we make a point about defenses of latches and waiver against the city.
Yeah.
Those are inherently factual arguments. While the commission can certainly grant summary judgment on something like 204 in favor of Vista or DEQ, but that's not proper on behalf of the city.
I want to make certain that I still have 15 minutes. Have I overlooked anything in anybody's arguments? Because there were a lot of points that were raised. Have I missed anything? I mean, there's been cross motions. I didn't pick up or didn't express that a lot of your motions were cross motions for summary judgment, and I apologize for that. But I think we fleshed everything out. I hope I haven't missed anything. If I have, of course, we're going to have a post-hearing motion for summary judgment brief on the one narrow issue of 203. In my interpretation of it, nobody else's. So if you need to add something that I missed in the motions for summary judgment, don't even brief it, just send me an email and then we can talk about potentially addressing that if I skipped over something. I don't think I did. I think I had it all laid out, but if I did, I apologize. Anything else from anybody else? I appreciate everybody's time today. And I hope we can get this thing resolved in a fairly expeditious fashion. We're off the record.